Very well, we resume the debate on the principles of P107, the Draft Children and Young People Jersey Law. And next listed to speak is Deputy Doublé. Deputy Doublé.
Thank you, sir, and I'm pleased to follow the previous speakers, and Senator Mesick in particular said something which resonated with me, and he recalled the care inquiry, and I do think that it is important that we do recall that that moment in time, especially when we are looking at legislation like this, because we do need to remember the reasons behind some of these changes we are making, and to keep that that momentum going, in terms of having that purpose behind what we're doing, especially as we're winding up this term. And I think something that struck me in regards to corporate parenting, we were discussing this, the panel of which I'm vice chair. We had a hearing with the Children's Commissioner recently, and she said several things that really struck a chord with me. And one of the things that she said was that at the moment, in the past, and unfortunately still, there are children on our island who, having first been failed by their parents for various reasons, and then being removed from the care of their parents and being placed in the care of the state, the government, those children are at times still being failed. And that I found that particularly poignant, and I hope that this law can be a watershed moment and ensure that this stops and this does not continue to happen. And I see that the intention is there from government, and I think across the Assembly that we all agree that this is incredibly important. And what I wanted to add today is that I hope that that culture change can be sustained, not just in our government and in our Assembly, but actually across our island, because members will all be aware of that phrase, which is often quoted about taking a village to raise a child. And I think we all need to have that sense of responsibility for all children collectively in our islands, and treat all children, but especially the vulnerable ones, with the same care and compassion as we would our own. And I suppose what I would like to ask the Minister is, when we have this law in place, and I'm hoping this law will be approved, what work will be taken alongside it, alongside things like training, to actually make sure that this culture change is ingrained within government, and that culture change has a wider impact across our island. And I'd like to know how that culture change is going to be measured, because I think it's important that we do try to measure things like that so we can keep track of them and hold ourselves accountable. And I think it was Deputy Ward spoke about the voice of children, which of course was mentioned in our scrutiny comments. I think sometimes when we have these big changes and we create new legislation, sometimes we feel like the job is done. And what I would like to see, and again I'd like to ask the Minister, is how will the impact of this legislation be measured? How will we know the impact that it's having on the lives of children, and how will we know whether it's enough or not? So I'd like to know how children will be part of any work to review and measure the impact on this legislation. But I will be supporting it, and I thank the Minister for bringing it forward today.
Very much. Deputies, any other member wish to speak on the principles? If no other member wishes to speak on the principles, then I close the debate and call upon the Minister to respond.
Thank you, sir. Firstly, I'd like to thank all speakers, especially my assistant ministers, who gave some fantastic speeches, and I'll try and respond to some of the questions in some of the speakers. So Deputy Ward, let's say, highlighted the need to make sure that whoever's in the next government ensures that the training and the funds and the resources are able to make sure that the right level of training is put into place. And I fully agree with Deputy Ward in that area, that it will be the responsibility of whoever's in power in government after the elections to make sure that they carry on this work of the law, ensure that it's not just a law that sits dusty on a shelf, but it's enacted upon, and that people know their responsibilities and how to get the best out of this law to make sure that the outcomes of children are the best in this island. Deputy Ward also asked about whether the Treasury Minister should be put in place as one of the responsible ministers. I think another Education and Children's Minister might have a different view, or another Council of Ministers, but at the moment I feel that Treasury sits at a level of checks and balances as well. So the ministers will, the responsible ministers will put forward applications through the government plan and through other means to request the right level of funding and to support what's going on. The Treasury Minister needs to be able to look at the public purse in a way that looks across the whole of the island. Of course, making sure the funds are available to give the right level of service is something that I think everyone will be passionate about, and it will take a precedent over other things. So I don't think quite it's necessary, but if next term, when the new Assembly's in, they could look at that when we come back with the law, or we'll continue to speak to scrutiny as we go through. Senator Mezek talked about the UNCRC and embedding the UNC within our laws, and I mean, we're going a long way. I'll be lodging soon the due regard law, which will set out that every law amendment or new law, any changes will have to start with a child's rights impact assessment, and I'm hoping that in this Assembly in future times, the child rights impact assessment will become the normal for a debating point in any changes in law, about whether it went far enough or whether it was all considered properly. That's when I know that the due regard law will have the right impact, is because children's rights and the impact will start at the very beginning of what happens in the State's Assembly, to be discussed at a level that it's never seen before. Senator Valwa, of course, I will consider the points raised about corporate parenting and everyday lives, and I will say about the voice of the child that's been raised by Deputy Doublé and Senator Valwa. We have the Care Leavers Ambassadors that is part of, that's joined and is part of our corporate parenting board. And we do make sure we listen and hear their views about changes we make, or how the service is being provided for children in care. So the Care Leavers have set out a training package that they are starting to go round to train what it means to be a corporate parenting from a child in care, and they're doing an amazing job in a lot of time and energy in making sure that their views are articulated in the best possible way, and that people really understand what it means to be in care. Deputy Doublé talked about how do we gauge the impact. Well, within this law, it sets out that all responsible ministers need and corporate parents, they need to set out a plan and publish it and be held account to what they're doing for looking after children in this island. It's part of the statutory part of this law. So that will set out what the plan is that will be able to be scrutinised by the Assembly and be held to account for the delivery of those. So I would expect that the impact will be defined, what the impact should look like, and be held to account through the scrutiny process in this Assembly. So I'll leave it there and say that this really is a landmark day for Jersey in creating this law, and I'm so proud to be part of it. The scrutiny panel has outdone themselves here. It's been a marathon, and they have looked at every part of this law. They've engaged with the public and stakeholders. They've held us to account in it. The Children's Commissioner has met with me regularly and has done have looked at the papers and raised issues. It's been a real team effort to get where we are today, and I'm very proud of everyone for the work, the hard work they've done, and the multi-agency work that really has happened. And with that, sir, I'm going to propose the principles and ask for the appel.
Thank you very much. I'll ask the greffier to place a voting link into the chat. The vote is on the principles of P107. And I open the voting and ask members to vote in the normal way.
Can I vote pour, please, sir? I'm having struggling getting on.
Yes, Cantab, you vote pour.
Constable Troy, myself, poor sir, I can't get on.
Okay, thank you.
So I had some trouble getting on. I'm in there, so it might take a bit. There might be a delay with the voting. I don't know. It's
Have you voted
now?
now? Oh,
Yeah, it's working now. It's rather it's ready.
If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. The principles have been adopted. 37 votes pour, no votes contra, no abstentions in the link, and a further 5 votes pour, either in the chat or given orally in the chamber. Very well, Deputy Ward, does your scrutiny panel wish to call the matter in?
No, sir. Thank you.
Well, how do you wish to deal with the matters in second reading, Minister?
So I'm going to propose the articles on block, seeing as no one has raised any particular issue on any of the articles through the principles. I'll speak to each article. I'm afraid it's a long speech, and then we will vote them on block, if that's okay with you, sir.
That's absolutely fine. You can take it that way if you'd like to. Are you going to be proposing Article 5?
Yes, sir. I'm going to propose Article 5, and then any changes that need to happen will be brought back when we bring it back later.
Very well, you'll speak to members about that then.
Yes, sir.
Thank you very much indeed. Yes, in which case, please do propose them in that way, Mr.
Thank you, sir. And I apologise for the lengthy speech that's about to happen, sir, but it's such an important law that has many aspects within the articles that I feel it's necessary to get them on record, sir. So the draft law is to make provision to promote safeguarding and support the well-being of children and young people. And it's in 11 separate parts, including the schedule, and I'm going to go through them now. So in Articles 1 and 2 provides a number of definitions that are used throughout the law. The draft law, except where specified, applies to all children up to the age of 18. Where young people are referred to, it means young people who are aged 18 up to the age of 25 and are either care leavers or young people who have a disability. The draft law also provides a new definition of care leaver for the purpose of the law, which means an individual aged 16 up to the age of 25 and who has been looked after for a minimum period of 13 weeks, whether in aggregated or consecutively from the age of 14 up to the age of 18. We realise that there might be some other care experienced young people that it is right to support, and the draft law does provide for exceptions or additions to the eligibility criteria by order to be made should the needs arise. Any reference in the draft law to responsible ministers means the Minister for Children and Education, the Minister for Health and Social Services, the Minister for Home Affairs and the Minister for Housing and Communities. Safeguarding partners are also defined and include the chief officers of the administrations of the states for which the responsible ministers are each respectively assigned responsibility, the chief executive officer and the chief of police. In the draft law, health and development are defined in a holistic way, with development in the context of children, including behavioural, emotional, intellectual, mental, moral, physical, spiritual, or social development, and health meaning physical or mental health. The term services for children or young people in the law means any service or support which is provided exclusively or mainly to or for the benefit of children or young people. The term related service means any service or support which is not exclusively provided to or for the benefit of children or young people, but which is capable of having a significant effect on their well-being. It was intended that the 4 key United Nations Convention of the Rights of the Child, the UNCRC, general principles should be embedded in the draft law to reflect our commitment to continue to implement the convention following its extension to Jersey in 2014. This has been provided for in respect of an overriding objective in the draft law to promote and support the well-being and safeguard the welfare of children and young people. When carrying out functions under the law, the responsible ministers and the other corporate parents, safeguarding partners and relevant providers must have regard to the overriding objectives and to principles founded in the 4 general UNCRC principles, which are to take all appropriate measures to ensure that children and young people are protected against all forms of unlawful discrimination, have the best interests of children and young people as a primary consideration, have regard to the views of children and young people in all matters affecting them, with due allowance being made for age and maturity, and promote the health and development of children and young people. So in Articles 3 to 6, the central and repeating theme of the draft law is the promotion of well-being of children and young people in Jersey and to safeguard their welfare. This part describes a model of well-being and the assessment of well-being based on the established principles of a continuum of needs. Most children will thrive with the love and support of their family and family networks. However, for some children, varying levels of support may be required to successfully address the child's identified needs. Where more intensive support or protection is required, the provisions of this draft law are intended to work with the existing child protection provisions under Part 4 and Part 5 of the existing 2002 Children's Jersey Law. Wherever there is an assessment carried out under the law, it requires consideration of 8 indicators for well-being and explore to what extent the child or young person is safe, healthy, achieving, nurtured, active, responsible, respected and included. In order to assess children's well-being needs effectively and deliver services to meet children's needs in a timely way, strong joint working between service providers is essential. The draft law introduces 2 areas of cooperation to underpin joint working. Firstly, there is a duty placed on me and other responsible ministers to make arrangements to promote cooperation between themselves and other providers of services to children to promote the well-being of children and young people. This must be done with regard to the importance of the role of parents and other people caring for the children and young people in promoting their well-being. Ministers may also issue guidance under the provision of this part to give further clarity on what cooperation should entail. Secondly, this part formalises, updates and consolidates child safeguarding arrangements and the joint agency work that has already been established in Jersey in respect of children, which for the last 7 years has been through the non-statutory Safeguarding Partnership Board. The Safeguarding Partnership Board currently has responsibility for promoting understanding of safeguarding, helping agencies to work together to safeguard children, and monitoring how effectively agencies are working together to keep children safe in Jersey. This is overseen by an independent chair. Under the draft law, the safeguarding partners identified in this part must make arrangements for ensuring that their functions and those of other relevant providers are carried out with regard to the need to safeguard and promote the welfare of children and young people. They must also work together when safeguarding and promoting the welfare of children and young people. Independent scrutiny of the effectiveness of the arrangements is also provided for under the draft provisions. The draft law also allows the Minister for Children and Education to issue guidance that will provide further detail for the safeguarding partners and other relevant providers on what this means in practice, and also put in place a framework for annual reporting. Lastly, the draft law makes provision for the statutory review and analysis of child deaths. Regarding Articles 7 to 12, one of the key findings of the Independent Jersey Care Inquiry panel was that there was no common overarching plan for children, which took an outcomes-based focus. These series of articles in the draft law set out a framework for strategic planning for children and young people in Jersey, following the publication of the Care Inquiry's final report. A children's strategic plan was produced and produced and published. The draft law has drawn on experiences of producing and implementing the plan. Under the provision in this part, the Minister for Children and Education and the other responsible ministers, and in consultation with others, will prepare and publish a children and young people strategic plan for each 4-year period. They must also then report to the Assembly on the extent to which the plan has achieved the aims. The aims of the strategic plan are framed around the provision of integrated and efficient services for children and young people that best safeguards, supports and promotes their well-being, and that are based as far as possible on prevention. To deliver the aims, the Minister for Children and Education and responsible ministers and other providers will need to cooperate with each other to provide services for children and young people. Guidance produced under this part will be designed to make this clear. The approach is also supported by the duty to cooperate introduced in Part 2 of the draft law. Lastly, the draft law makes clear that children, young people and families need to know about the services provided. The Minister for Children and Education and other responsible ministers and the providers will publish details on services which will be reviewed at least annually. Articles 13 to 15, the draft law makes provision for the small number of children and young people who require targeted support to help meet their health and development needs by placing a duty on the Minister for Children and Education to carry out or arrange an assessment of those needs. A child with a health or development need is described in the law in a discrete category of need, which is designed to distinguish the more specialist types of assessment and services that may be required for some children and young people who are living with their families but have more complex levels of needs. This complexity may arise if earlier interventions are not having the intended effect or may be present from the outset for some children. This health or development need concept is a well-established concept in UK law and children's social work as children in need. A duty to cater for this vulnerable group of children has been absent up to this point in Jersey, and the draft law rights this situation. However, the definition in this draft law is broader than the one in the UK law and accounts for a range of children and young people who locally do or may require more targeted support to maintain or achieve a reasonable level of health or development. These include children with a disability, children affected with the disability, and someone in the family, children who are receiving specialist inpatient mental health provision, and children who are involved in the youth justice system. So it's important to note that under both parts 4 and parts 5, there is presumption that assessment, wellbeing plans and any support being offered to children and their families is an opt-in basis, and that any service provision and data sharing will be based on informed consent from the children and families who work with practitioners to achieve improvements to their child's well-being. The Minister for Children and Education will have a general duty to this group of children to provide a range and level of services appropriate to meet their assessed needs. The law enables the Minister to make arrangements with other providers in order to do this. Additionally, measures specifically addresses the provision of services for children affected by disability, including a requirement to provide assistance to people who are caring for children with disabilities, commonly known as the provision of short breaks. Part 5 is the Wellbeing Assessment Plan. This sees Articles 16 to 23 and makes provision for the assessment of children with wellbeing need and for wellbeing plan for individual children where there is an assessed wellbeing need or an assessed health or development need. Articles 16 and 18 provide for variations in respect of wellbeing plans depending on the type and extent of the need as set out above under paragraph 4. That is to say, whether the child is assessed at the present time as having a wellbeing need, or if they are considered to be in a smaller group of children assessed to have a health or development need. Equivalent measures for looked after children and for care leavers are contained in part 7. These individual wellbeing plans are designed to formalise the planning and review cycle in respect of targeted interventions that are put in place to meet individual children's needs. A wellbeing plan will be put in place where it is agreed by the family, the child and the minister or the appropriate practitioner in SIPES that it would be beneficial that the family support and universal services available to the child will be augmented by a plan specifying the additional targeted support required to meet the assessed needs. The plan will also provide a record of progress against the wellbeing and/or health and development goals. Articles 19 to 22 in this part provide additional detail in respect of the content of the plan, the preparation of the plan, the delivery of the plan, and the management or review of the plan. Article 23 of this part provides for the Minister for Children and Education to issue further guidance on wellbeing plans, and this guidance will form an important support to practitioners. I'm going to cut into my speech there, sir, as it is part 5 that we were talking about. It's been identified just today by the Solicitor General that there is a law drafting issue with the wording within these articles, and we plan to, when bringing back to the Assembly for the next part of this law, to amend that. So we will deal with the law drafting part at a later date, sir. Is that sufficient?
But yes, it possibly is, Minister. You are therefore still proposing that part of the law to be passed in this form, but informing members that you're going to be bringing forward an amendment in due course. Is that?
Yes, sir.
Is that what you're saying? Yes. Well,
that's correct, sir. In
which case, that's a matter for members and to raise during the course of the debate, of course.
Thank you, sir. I will let the members know. I was only made aware of this over the lunch period today, so it's very new to me as well, sir. Part 6 is the part on corporate parenting and sees Articles 24 through to 34. Articles 23 to 34 is about corporate parenting and applies to looked after children and care leavers. When a child or young person comes into care, the government becomes their corporate parent. Here, corporate parenting duties and responsibilities are defined and are proportionate to the corporate parent's likely role and involvement with children in care and care leavers. The named corporate parents are in the schedule, which can be modified by order subject to consultation with those affected. The named corporate parents have been selected to reflect the central role of the public authority as a corporate parent, along with early years in educational settings and a small number of arm's length or funded bodies that will together provide a well-rounded and broad perspective across the key domains of well-being. Part 6 sets out a framework for collaboration between the named corporate parents in respect of planning, reviewing and reporting to ensure that the process has opportunities for learning and improvement as well as accountability. This monitoring and review will be driven by the formation in law of a corporate parenting board whose principal functions is to monitor and review the discharge of corporate parenting responsibilities and other functions of corporate parents under this part. A key part of improving outcomes for this vulnerable group of children and young people is to take this more strategic and joined up approach to these children and young people's needs. A requirement for corporate parents to publish information about any services it offers, if any, to this group of children and young people will form part of the local offer first established in 2020 in conjunction with the services provided to children in care and care leavers by the Minister in Part 7 of this law. The provision in the draft law will also allow for guidance for corporate parents to be issued by the Corporate Parenting Board, and this will in practice be supported by training for corporate parents, which has already been successfully modelled in Scotland. In Articles 35 to 40, imposes duties on the Minister for Children and Education in respect of looked after children and care leavers. As with the support delivered to children in Parts 4 and 5, the support for children in care and care leavers in Part 7 is to be delivered by applying the same principles of wellbeing assessment, planning and review, which it sets out in Article 36. It is intended that the provisions here are to be supported in practice by statutory guidance, and the Minister for Children and Education has additional duties to publish statutory guidance under this part. In order to promote the health and development of children in care and care leavers, Article 36 places a duty on the Minister for Children and Education to carry out and arrange a wellbeing assessment of each looked after child and care leaver. This assessment should determine their wellbeing needs, which include their health or development needs. This is to be set out in a wellbeing plan. A statement of the young person's needs and targeted interventions required will be detailed in the wellbeing plan, along with how they are to be provided, by whom, and the outcome each targeted intervention is intended to affect. Timescales for review are also to be contained in the plan, and also the arrangements for taking account of the child or care leaver's views within the plan. It is intended that these provisions are augmented through the guidance provisions in Articles 37. The Minister will have a duty to issue guidance which will aid implementation of the law, interpreting the law into operational practice. Guidance may include the management form, process and arrangements in respect of the wellbeing plan, guidance as to the content of the plan, guidance on assessing progress against the outcomes and on reviewing and recording the plan. Article 38, let's start that one again so it's clear. Article 38 also places a general duty on the Children and Education's Minister to provide a range and level of services appropriate to meet the assessed wellbeing needs of looked after children and care leavers up to the age of 25. Articles 39 and 40 require the assessment of a personal advisor for each child transitioning out of care up to the age of 25 and imposes a duty on the Minister to maintain a staying put arrangement for any eligible care leaver up to the age of 22. This is intended to allow a gradual transition from being looked after into independent living. Nearly there, sir. Articles 41 to 43. Here further requirements on the Minister for Children and Education are introduced in respect of looked after children. Firstly, the Minister must appoint a person to promote the educational achievements of looked after children, which will formalise the role known as the virtual school head. Secondly, a requirement to appoint an independent reviewing officer for each looked after child is introduced, along with measures relating to their role, appointment and qualifications. Thirdly, a duty to review the case of each looked after child is imposed, which must be in accordance with a published policy in respect of this review process. Articles 44 to 46 in Part 9 of the draft law gives a power to the states to make regulations to require the Minister for Children and Education to make reasonable arrangements to make provision for independent advocacy. This is to act on behalf of children who have their health or development need, children who are looked after and for care leavers. This may be extended to other groups of people if they are later identified in regulations. I have already instructed officers to begin scoping this work with a view to developing drafting instructions later this year. The draft provisions also set out a range of elements. The regulations on independent advocacy might include such as the appointment of advocates and their role, the conduct and powers. Further, provisions may include matters relating to the help to be given to children and care leavers. We will be consulting on the detail of the arrangements for advocacy, as we want to make sure that children's voice and experience are central to this area of policy and practice. Under this part, the Minister must also establish and publish a written procedure for considering representations and complaints made about the discharge of functions in respect of children and young people under parts 4, 5 and 7 of the draft law, and also provide scope for including aspects of the Children's Jersey Law 2002 and the Adoption Jersey Law 1961. So in Articles 44, 1 and 2 refer to the legal term may and not shall or must. This is because any definitive wording of the law in this article would undermine the sovereignty of this Assembly, instructing the Assembly and forcing an outcome, removing the right of the Assembly to make a decision. So Part 10, closing provisions. So the final articles 47 to 49. This part makes provision for transitional, consequential, incidental, supplementary or saving provisions for amendments to the Children's Jersey Law 2002 and for citation and commencements. So with that all said, I propose the articles from 1 to 49 and ask for the appel.
Well, we're not quite ready for the appel, Minister. We have a
Sorry, yes.
schedule first. But before I ask for that to be seconded, Deputy Ward has indicated he'd like a point of clarification relating to the nature of the drafting error to which you made reference. And if I could simply ask, because the information I've been provided is not that the drafting error related to Part 5, but that it related to Article 5 and specifically Article 5.4. But it could be that that information is not correct. So I wonder if you would feel able to explain. Alternatively, perhaps the Solicitor General, if you'd wish to call upon him, but that's entirely a matter for you.
So it's just about clarification, because obviously we've done an enormous amount of work on this and this is news to us, and it may just be a small error, but I think it's important that the Assembly understands what it is.
Are you able to help, Minister, or is that something we'll wait for it to be seconded and then ask the Solicitor General?
I think I will have to ask the Solicitor General. I will correct that it is Article 5 and not Part 5, and I made that error there. It's all very much happened at a very last minute. So could I ask the Solicitor General to clarify what was the perceived error, please, sir?
Yes, Mr. Solicitor, are you able to assist the Assembly?
So yes, I can. If the Assembly have open Articles 4 and 5, I will explain what is a fairly limited error. But Article 4 is concerned with the responsible ministers as amongst themselves and between themselves and relevant providers to promote well-being. And Article 4, paragraph 4, effectively, in simple terms, requires them to talk to each other and to share information that is relevant to promoting well-being. The same principle that people should be talking to each other was plainly intended for Article 5, which concerns safeguarding partners and relevant people. Similarly, talking to each other to promote the welfare of children. If the Assembly looks down to paragraph 3E of Article 5, safeguarding partners are required to have arrangements in place to disclose information between safeguarding partners and relevant providers. And then dropping down to subparagraph 4, arrangements under paragraph 3E must not permit the disclosure of information that relates to information obtained. In other words, it mirrors the provision for people to talk to each other in 4.4, but turns it on its head by forbidding them to talk to each other. The not in paragraph 4, arrangements under paragraph 3E must not, the not is plainly in error, and it should not be there. And there are one or two minor changes that follow. The word and at the end of Roman, forgive me, the word or at the end of Roman 1 and the word or at the end of Roman 2 both need to change to read and. So I hope that's clear.
Thank you very much.
So may I just ask the other little part there? Can I ask the Solicitor General what the implication would be of passing these regulations, these articles today as written would be, and how quickly that amendment would need to come forward, and just the implications of where we are at the moment, really. Thank you, sir.
Well, I think the answer to that is unless and until this proposition is adopted and receives the royal assent, it has no practical effect. As to how long it would take for it to be amended, I think that's not matter for me to advise on. It would seem to me more matter for either the minister or the presiding officer.
I think that I'm having in mind I would need to consider the provisions of Standing Order 75.4 of the Standing Orders of the States of Jersey, which says an amendment to the draft may not be proposed during the debate. This is talking about third reading, although a clerical error or oversight in it may, with the permission of the presiding officer, be corrected. So I would have to give some little consideration as to whether that amounts to a clerical error or oversight requiring 3 changes, but that mechanism would be possible. Reverting to you, Minister, obviously we haven't, you've proposed, we haven't yet got seconding for the articles, but it seems to me that the way that it is possible to go forward is either having adopted the articles to defer the rest of the debate and bringing back an amendment to correct that point, or for me to give consideration as to whether it can be corrected under that rule to which I've just made reference. Do you wish to say anything more before we call upon this to be seconded, Minister?
So I think I would like to continue with this debate and ask for the articles to be approved and for you to consider the options for a change in third reading. If not, we will bring forward an amendment as soon as practically possible.
Very well. Well, I will give some consideration, but I would, in order to assist, although it's for me to interpret standing orders, if any member clearly has concern that these changes should not be made under the rule, then I would be grateful to hear from them, simply so that I'm able to test the mood of the Assembly, although, as I say, it is entirely a matter for me and interpreting standing orders as to whether or not that amendment can be made. Very well. Are the articles seconded? Yes, the articles are seconded. Very well. Would any member like to speak on the articles in second reading? no one wishes to speak on the articles in second reading, then I close the debate and call upon ask the greffier to place a vote into the link.
Sorry for clarification, apologies. So we're voting for all of the articles and then we'll
Yes.
come back to see
No,
whether
no one has asked for Article 5 to be taken separately. Therefore, we're voting on all of them, and they will be all passed or voted against as the case may be. And then we will, in third reading, need to consider. Well, I will need to consider what the consequence of that may be, and either, as the Minister has indicated, there will need to be an amendment at a later date, or it can be changed under that slip rule. Very well. I ask the greffier to open the voting and members to vote.
Sir, I'm having trouble with my computer. Can I vote for verbally?
You can indeed, Deputy.
Thank you.
We have 39 members cast the votes. If members have had the opportunity of casting their votes, I ask the greffier to close the voting. The articles have been adopted in second reading. 39 vote pour, no votes contra, 2 abstentions in the link, and a further 4 votes pour in the chat.
Could we have the abstentions, please, sir? Read out.
Those abstaining in the link, Senator Valois and the Connétable of Greville.
If members would bear with me for a moment. It seems to me that the normal way in which this standing order is used, 75-4, is to deal with things that are clearly clerical amendments, clearly things which have been mistyped or misplaced or renumbered or needed to be changed. And it would, in my view, create a dangerous precedent were I to permit a substantive alteration to the meaning of an article to take place in third reading. Accordingly, I'm not prepared to exercise and grant my permission to amend under Standing Order 75-4. I am conscious, and this is by the by, that it is not intended that this law is brought into effect before 2023 in any event, where there's an appointed day act, and there is ample opportunity for the drafting to be corrected by an amendment before it comes into effect. Accordingly, in dealing in third reading, we will be dealing with the articles as adopted in second reading. Minister, do you propose the matter in third reading?
Yes, sir.
Is it seconded for third reading? Does any member wish to speak in third reading? If no member wishes to speak in third reading, Connie Tarbison, John.
So are we able to take the articles separately and keep that one article?
I'm afraid not, Connie Tarbison. That could have happened in second reading, but in third reading, it's simply do you adopt the members adopt the law as it is being approved in second reading.
Thank you, sir.
If no other member wishes to speak in third reading, I close the debate. And I ask, well, in theory, Minister, I ask you to respond because there's been an intervention.
Thank you, sir, and thank the Constable for just highlighting that. So, firstly, I apologise. It shows that when we're dealing with large laws, even the level of scrutiny this has been through, sometimes little things do slip up, and I do apologise for that, sir, and we'll endeavour to get this amendment brought forward as soon as possible, seeing as it's just a small amount of words that just need to swap round and put the word "and" in. So I will endeavour to get that done as fast as possible, sir. So this Children and Young People Jersey law is a significant advance in the promotion and protection of children's well-being in Jersey. It allows this assembly to continue to complete its public commitment to learn the lessons from the Care Inquiry and continue to strive to put children first. I'd like to thank again scrutiny that make the officers, the Law Officers Department, and everyone. This has been a really big group effort to get where we are, and it changes the landscape of how we do things in Jersey for the better. Sir, we are all somebody's child, and with that, I'd like to be very proud that this law is getting passed today, as it's my mother's birthday. So I wish her what I believe would be, I believe it's 21 again, for her birthday on this monumentous day, sir. To close, I'd also like to thank my fellow council ministers and scrutiny colleagues for their support in bringing it forward, the Children's Commissioner, and many more who you are the Care Commission. And I want to thank my officers that have worked tirelessly to get this where it is today. And with that, sir, I propose the articles in third reading, sir.
There are they second? They are second. They've been seconded and debated. I ask the Greffier to place a vote into the link. I open the voting and ask members to vote.
Mine's poor, so that's no connection.
Members have had the opportunity of casting their votes. Then I ask the Greffier to close the voting. The law has been adopted in third reading, 39 votes for, no votes contrary, 2 abstentions in the link, and a further 3 votes noted for either in the chat or on the floor of the Assembly. Very well. The next item is the Draft Companies Amendment number 8, Jersey Regulations P108, lodged by the Minister for External Relations and Financial Services, and I ask the Greffier to read the citation.
Draft Companies Amendment number 8, Jersey Regulations 2000. The states make these regulations under Article 194A of the Companies Jersey Law 1991.
Minister.
So if I could intervene, the Minister unfortunately is not available today and has asked me to take this as rapporteur, and indeed the next item as well.
Certainly.
Thank you, sir. So the draft Companies Amendment 8 Jersey regulations seek to add to the potential remedies available to a creditor of an insolvent Jersey company by permitting a creditor to apply to the Royal Court for the company to be wound up and a liquidator appointed. The regulations amend the Companies Jersey Law 1991. The procedure seeks to adopt established concepts and processes from within Jersey and also in other jurisdictions, so that being based on tried and tested concepts and procedures already familiar to practitioners, it will be widely understood. And as noted, it adds to the existing provisions such as en disastre, which will of course remain available to creditors. In considering that the reform will support Jersey's reputation as a leading finance centre which recognises the interests of creditors, whilst also providing appropriate protections for the debtor company. It is to be noted that these provisions affect Jersey companies only and not individuals. They are introduced after public consultation with the industry bodies, the Viscount and the Jersey Financial Services Commission. So the regulations will be supported by an accompanying order which amends the qualifications required of a liquidator, widening the categories to be included as an licensed insolvency practitioner alongside qualified accountants, and to impose additional experience requirements. This is to ensure that only suitably qualified persons with requisite experience are appointed. In addition, the order establishes a register of approved liquidators to be administered by the Viscount for an annual fee. The Viscount will also have a role in relation to the receipt of any complaints and the conduct of any particular winding up. So the regulations introduce the concept of a statutory demand, which is commonly found in other jurisdictions, and assists in formalising evidence of the insolvency of the debtor. So the regulations also permit the court to appoint a provisional liquidator who will be able to take steps to preserve assets where there is a concern the assets will be dissipated or the affairs of the company will not be properly conducted between the applicant to court and the making of a winding up order. So no additional resources will be required as a result of these regulations. However, it is right to note that this is an alternative process to a disaster, and the potential effect is there may be fewer or less remunerative disasters to be administered by the Viscount, which could have a consequential effect on the income of the Viscount's department coming from this area. However, we don't believe this will be significant. It is expected that it will be limited by and may be partially offset, at least in part, by the anticipated income for liquidators' registration fees. The Viscount has indicated that despite any such effect, she supports the introduction of this process. So as I've said, these amendments have been consulted on widely and were broadly supported. And in conclusion, the amendments do not remove any remedies available to those owed money by a Jersey company. They simply add a further option, and one that is well recognised in other jurisdictions. If adopted, this change will make Jersey companies more attractive to the banking community as a sound lending proposition. So I propose the principles.
Are the principles seconded? Does any member wish to speak on the principles? Yes, Deputy St John. I beg your pardon, Deputy St Mary.
Thank you, sir. I hope members will have had the opportunity of considering the comments paper issued by the Economic and Industrial Affairs Scrutiny Panel towards the end of last week. We there referred to the fact that we had a briefing from the Assistant Minister and his officers, and when they went through not only the proposed law but also the consultation process. That consultation process supported the idea that there was a general consensus of the need for these provisions, but it also identified a divergence of opinions on certain matters. Given that the consultees were largely members of the legal profession or accountancy or insolvency practitioners, the panel obviously took serious consideration of these, and we're grateful to the Minister and Assistant Minister for allowing us extra time for our review. After that initial briefing, we did have a further briefing, and when the officers went through very comprehensively the concerns where there was divergence. Again, if members refer to our comments paper, you'll note that there are three particular items which were the deemed commencement date of the winding up, the statutory demand, and the need or otherwise for a provisional liquidator. As regards the need for a provisional liquidator and the commencement of the data commencement of winding up, it is the case, as we understand it, that the law or the draft law was amended during the course of the consultation period, and there is the option by the court to decide which date is preferable. As far as the reservations concerning the statutory demand are concerned, we were provided with quite extensive information of what appeared in documents in the UK in particular, which would ensure that a demand made under these provisions would not somehow jeopardise the debtor in others. And again, so we have been suitably assured on that front that the final version, if I can call it that, does represent a fair balance of the views. In our comments paper, we do conclude by quoting 2 paragraphs issued by the Minister, which refer to that very point, that and ends where there was a continuing divergence of views. The matters were very carefully considered, and the position adopted, which was considered would optimise the operation of the process, and on the basis of the strong support for the proposals from certain respondents in counterbalance to the opposition of others. We conclude, therefore, as a panel, that the proposition as lodged does take account of both sides of the argument in respect of those areas where there was divergence, and we are minded, therefore, to support the proposition as is. Thank you, sir.
Thank you very much indeed, Deputy. Does any other member wish to speak on the principles? No other member wishes to speak on the principles? Then I close the debate and call upon the Contact Hubson 1 to respond.
Thank you, sir, and I thank the Deputy Mayor and his panel for their hard work on this proposition, and indeed we've had some extensive discussions with them, which have been ultimately very fruitful and resulted in the final version of this proposition. And also, I think we all felt that a number of concerns and issues raised by industry were thoroughly aired, and the end proposition has resulted in a fair and balanced proposition, which I think keeps the vast majority of people involved happy. For my part, I believe that this is, as an ex-lending banker, I believe this is an excellent addition to Jersey's range of options, and I think it makes local companies more attractive to UK and overseas lenders, because it adds a number of provisions which are used elsewhere in the world to our laws, in addition to the unusual on disaster proceedings we already have. And as such, I recommend and commend this proposal to the Assembly and ask for the appel.
Thank you very much indeed, Conatap. I'll ask the Greffier to place a voting link into the chat. Open the voting and ask members to vote. If members have had the opportunity of casting their votes, I ask the Greffier to close the voting. Principles have been adopted, 42 votes pour, no votes contre, no abstentions in the link, and a further 2 votes pour in the chat. I take it, Deputy St Mary, your panel doesn't call the matter in?
No, sir, we do not. Thank you.
Then Conittab, how do you wish to deal with the matter in second reading?
With the indulgence of the Assembly, I'd like to take the regulations en bloc, just with a brief overview beforehand. The regulations amend the company's Jersey Law 1991 to enable the proposal to be implemented, and as such there are quite a lot of them, but none of them are of any great significance. They simply implement what we've already just voted on, and so I would like to propose them en bloc.
Are they seconded in second reading?
Sorry, yes, sir.
Does any member wish to speak in second reading? If no member wishes to speak in second reading, then I close the debate and ask the greffier to place a vote into the link. Link into the chat, rather. I open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. Regulations have been adopted in second reading, 41 votes for, no votes contre, no abstentions in the link, and a further 3 votes for in the chat. Do you propose the regulations in third reading?
Yes, I do, sir. If I could just say a few words as well. That's
of course.
Thank you, sir. I'd like firstly to thank the Deputy St Mary's and his scrutiny panel for their engagement on this matter, which has been very useful, and I appreciate the work that they've had to put in to get us to this stage. Also very much like to thank my officers who worked incredibly hard as well to get us to this stage. And with that, sir, in the interest of brevity, I'd like to propose the matter in third reading.
Is the matter seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? No member wishes to speak in third reading. Then I close the debate and ask the greffier to place a vote into the link. A link into the chat. Open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The regulations have been adopted in third reading, 39 votes for, no votes contre, no abstentions on the link, and a further 2 votes for noted in the chat. The next item of public business is the draft financial services amendment of law number 6, investment business Jersey regulations P112, proposed by the same minister And I ask the greffier to read the citation.
Draft Financial Services Amendment of Law Number 6, Investment Business Jersey Regulations 2000. The states make these regulations under Article 4.2 Financial Services Jersey Law 1998.
Conisar.
Thank you, sir. So the Draft Financial Services Amendment number 6, together with the Draft Financial Services Amendment of Schedule number 3, which has been lodged with the amendment law as an attachment to it, operates as a legislative package to bring into regulation for those providers who are giving investment type advice to consumers about their Jersey pension products or private employer pension arrangements in Jersey's retail pension business. The amendment law, together with the draft order, will play an important role in ensuring that there is better protection for consumers in respect to the sales advice they receive when looking to take out a pension product or exercise their rights to deal with their pension benefits by converting them into lump sums, transferring to other pension arrangements, or into a new policy, or making decisions about how to invest their pension pot, or defer taking it early as a member or a policyholder of their Jersey pension arrangements. So it closes a gap in the regulation of such advice, which was partially closed in 2018, when advice and retention in relation to the transfer of defined benefit pension rights was brought into regulation and into the scope of Jersey's investment business regime. It does not seek to address advice given by employers to the employees or other types of advice, which are more in the nature of information rather than real advice as to the merits or dismerits of a product or member of a policyholder exercising their rights. The effect of the amendment law and draft order on those providers who are not already licensed to give investment advice will be that their regulatory status is altered. They will need to apply for a license to carry on this activity. If they were not already a regulated business, they will need to find this. They will find this as a change of their regulatory status, which will alter their tax status so they're taxed at 10%. It is understood that most providers who would have been affected in this matter were caught by the previous changes to the investment business regime in 2018, when advice on defined benefit arrangements was brought into regulation. No providers were forthcoming when the amendment law and the draft order were consulted on in September last year, despite the consultation specifically seeking their views and engagement, and the consultation being shared with relative industry associations. So those providers who are brought into regulation by the amendment law were required to comply with the Investment Business Code and Business Codes of Business and will need to provide suitability letters providing this type of pension investment advice. Their activities will fall under the supervision of the Jersey Financial Services Commission. So the government has consulted extensively with industry in the preparation of this amendment law and the associated draft order. I will summarise briefly how the changes made to the amendment law and how it works alongside the changes made in the draft order. So the amendment law introduces a definition of subscription. This widens the definition of this term, which is used in its ordinary sense throughout the law, to expand it to include investment business activity of advising individuals as an investor or a potential investor when they are looking to take out a pension policy or join a scheme. This definition does not capture the advice given to an employer who is looking to set up a pension scheme, and its wider scope is limited only to the specific activity in respect of Jersey approved pension scheme arrangements. The draft order amends the investment business schedules, firstly by adding a Jersey tax approved pension arrangements to the list of investments which are within the investment business regime. This substituting the previous inclusion of a defined benefit scheme alone. Secondly, by making it clear that the scope of this regulation of a pension scheme as investment is limited to advice only. And lastly, by removing the investment business exemptions that have previously existed for defined benefit schemes and the advice given to members of an occupational pension scheme to avoid confusion where there is an investment business manager or advisor appointed to act in relation to such pension schemes, they need to be licensed and this activity will be regulated. The amendment law and draft order will give immediate effect as the changes have been long rehearsed and awaited by industry, and the Commission is ready to enable them immediately. The amendment law does not introduce any new penalties. For the first time, all investment type advice given to consumers in the local retail space for pensions will be afforded the same protection as advice given to other types of retail investments, with greater clarity on cost and the risks attached to the investment decisions being made by the individual. This should be of significant benefit to our domestic community and will improve the behaviours and standard advice given by providers. So the amendment law will ensure advice given in the retail market to our consumers about their pension products is regulated. And so I propose the principle to commend this to the Assembly.
Thank you very much indeed. Are the principles seconded?
Yes, sir.
Deputy St Mary?
Yes, thank you, sir. And this proposition is somewhat simpler than the previous one. Again, so we have had a full briefing from the Assistant Minister and his officers, and we are satisfied that this is a necessary and worthwhile step. So the panel does support the proposition. Thank you, sir.
Very much. Any other member wish to speak on the principles? No other member wishes to speak, then I close the debate and call upon the Conitav to respond.
So as with the previous project, I should like to express my sincere thanks to the Deputy St Mary's and his panel, who once again provided us with very thoughtful and engaging discussions about this particular change to the legislation. And also, I'd just like to make the point that this is something personally, for me, this gives me much pleasure to bring this piece of legislation to the Assembly. I started work on this the first day I joined as a new member, and I'm delighted to be able to present this to the Assembly today. And I make the proposal, sir.
Very well. Ask the greffier to place a vote into the link. Vote is on the principles for P112. And I open the voting and ask members to vote. Members have had the opportunity of casting their votes. I ask the greffier to close the voting. Is there a result in there, greffier?
Yes, I don't know why it's come up like that. Do it again.
The principles have been adopted. 40 votes for, no votes contra, no abstentions in the link, and a further 4 votes for noted in the chat. Deputy St Mary, I take it your panel doesn't call this in?
No, thank you, sir. We do not.
Very much. How do you deal with the matter in second reading, Conitav?
So I would like to, there are only 2 articles as I outlined in my initial speech, and I'd like to take both of them together if I could.
Of course.
And I make that as a proposition, sir.
Very much. Is it seconded for second reading?
Yes, sir.
Does any member wish to speak in second reading? If no member wishes to speak in second reading, then I close the debate and ask the greffier to place a vote into the link. I open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. Regulations have been adopted in second reading, 41 votes pour, no votes contra, no abstention in the link, and a further 2 votes pour in the chat. You propose the regulations in third reading?
Yes, sir. And as with the last proposition, I'd like to make just a few quick comments before I do so. Firstly, I should once again like to thank the Deputy St Mary's and his panel for their engagement and hard work on this. And secondly, I should, on a more personal note, this is something that I feel particularly pleased that the Assembly has supported so far. However, I'd just like to point out to the Assembly that this is the start of regulating pensions in Jersey, which something, in my view, which should have happened some while ago, and that more regulations will be coming to the Assembly, but it won't be during my term. But I thank members for their support so far, and I'd like to make the proposition in third reading, sir.
Thank you very much indeed. Is it seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? No member wishes to speak in third reading? Then I close the debate and ask the greffier to post a link into the chat. And I open the voting and ask members to vote. Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. The regulations have been adopted in third reading. 41 votes pour, no votes contra, no abstention in the link, and a further 3 votes pour in the chat. Very well, the next item of public business is the radiotherapy unit in Jersey, P113, lodged by Deputy Tadier. There is an amendment lodged by the Minister for Health and Social Services. Deputy Tadier, do you accept the Minister's amendment?
I do, sir.
Very well, are members content to take the proposition then as amended? Anyone would indicate in the chat only if they are not content. Very well, I will take that as approval and I ask the greffier to read the proposition as amended.
The states are asked to decide whether they are of opinion A, that subject to the outcomes of parts B and C below, and considering first and foremost the best outcomes for patients, Jersey should have its own radiotherapy unit for the treatment of cancer patients. B, to request the Minister for Health and Social Services to explore options for delivering a radiotherapy unit in Jersey and for improving the experience and health outcomes for cancer patients. And C, to request the Minister for Health and Social Services to present the option appraisal and recommendations to the States Assembly no later than April 2022.
Deputy Tadier.
Thank you, sir. First of all, if I can start by thanking the Minister for his engagement and his officers on this, what I think is a very important subject for those whom it affects. I know that the Minister and his staff have been under a great deal of pressure recently and a great deal of scrutiny from members in the Assembly. Pass no comment on that, but to say that I recognise that he's got a lot in his work stream and that I value his personal commitment as well as his professional commitment to seeing if what we're asking today can be done. So I do want to try and keep it relatively brief, but at the same time bring in some direct experience from some of the patients and the users of the service so that we can better understand. And I say this quite humbly because I know that other members will also have direct experience. And in accepting the Minister's amendment, I recognise that there's always a balance to be struck when we bring something in principle. I've been told in the past that politics is the art of the possible, and it should be it should be for us to be able to have debates on principles about what we want to do as an assembly, as a community, as an island, and what kind of facilities and services we would like to provide, albeit within the realm of the possible. And I think this is what the proposition does. It recognises the fact that as a small island, we often have to make tough choices about what we can deliver, about how services are best delivered. But at the same time, I would always be aware of the fact that we're not just a typical small community, we're a close-knit small community which also has trillions of dollars, euros, pounds passing through it every day. I'm not sure how much of that stays here, sir. So I'm just having...
Do you have some difficulties, Deputy? We've stopped hearing you. Deputy Tadier? Deputy Tadier?
Thank you, sir. Sorry, I think did everybody?
Deputy, you're fading in and out, and I think we just got past the point when you were going to discuss some personal experiences relayed to you, presumably by people, but then you faded out. I don't know if you can hear me, but we can't hear you at the moment. Suppose that we stand adjourned for just a couple of minutes to see if we can get Deputy Tadier rebooted, or whatever it is he needs to happen to him in order to continue.
Hello, sir. Does that work?
Is he back?
Sorry.
I just shut down my Teams and re-logged on. Can members hear me?
Hi, Monty. Yeah, we're just adjourned until you get sorted, but you seem to be coming over quite clear now.
Okay, I don't know where I got to, but I think the sound cut out.
Okay, hang on.
Monty, you got to the point where you were about to talk about people's experiences, but when the bailiff gets back, that's probably where you should lead on from.
Okay, sorry about that. It's the old switch off, switch on again seems to have cleared the issue. That's fine. I'll just get my notes back up. So you didn't hear any of me reading out the experiences of people, no?
No, unfortunately not. If you could repeat that part, that would
right.
be where the good starting point would be, I'm sure.
Thanks, Scott. Sorry. Thanks, Deputy Wicken. Hello, sir.
I think the bailiff's on mute now. It's
I know.
see no evil, speak no evil.
I can't hear now.
So you're showing us on mute.
None of us can hear Monty.
Okay. Can you hear me now, Deputy Tadier?
I can, sir. I'm sorry about that. I don't know what happened. Can you hear me?
Yes, we can hear you, and I think we're ready to resume. I think people both have sound and for their sins vision. And if you could then continue with your proposition. Thank you.
Thank you. I'm sorry to members for that. I understand that nobody heard me starting to make the comments about the personal remarks. So
that's right.
Okay, so just to preface this, it is clear to say that different people will have different experiences, and I think I said before I got cut off that including members of the Assembly will have personal experiences and experiences with their families and loved ones, and they're all different, and I'm aware of that. And I'm also aware of the fact that people, when they're feeling vulnerable, have been very grateful for the care that they've received, whether it's on island or when it comes to radiotherapy off island, and they recognise that. But similarly, I think we have to realise that it's often very stressful for people to go away. It's not just stressful, but it can be sometimes more than that. There will be a section of Jersey community who don't decide against travelling away exactly because it's too traumatic for them. We don't necessarily know about those people, and we don't know what the outcomes might have been if they had decided to have treatment, or indeed if we were able to provide treatment on island. So with that in mind, I will just refer to two individuals. I've spoken about people in my proposition, and I know members will have had the chance to read that. So I've been given permission to share verbally these two stories. I'll try and abridge it somewhat, sir. The first person is we'll call her Catherine. She's happy to be known as Catherine, that's her name. Said I was diagnosed with breast cancer in April 21. After I received the news, I was told I would have surgery. I would go to Southampton. As soon as the wound from surgery had healed, I was in shock. To be honest, I didn't question the element where I would have to go off island for treatment. I just accepted this as the treatment plan. The appointment was with a specialist in mid-May in Jersey, and I was told I'd receive radiotherapy in Southampton in about 6 weeks' time. I'd calculated this to be around mid-July. It transpired that my appointment wasn't going to be until August. My husband and I were having a blessing ceremony on the 22nd of August for our marriage, which we'd had during the lockdown. I had a stressful time trying to bring the appointment forward for radiotherapy, as I felt that after the after effects would clash with our blessing. I had been warned that it was likely that I would be extremely tired after the treatment and may possibly hit a wall around 9 days post-treatment. I was able to bring the treatment forward by 1 week by attending the radiotherapy treatment at Basingstoke Hospital, which is part of the same trust as Southampton. She goes on to say that my initial CT scan was at Southampton Hospital on the 13th of July. I had to fly from Jersey at 7 AM for a 10 o'clock appointment at Southampton Hospital. The only flight available back to Jersey was after 8 PM. This was actually delayed. It was an extremely long, tiring day, and I didn't get home till 10:30 PM. I eventually commenced radiotherapy on the 2nd of August at Basingstoke. I stayed with some family in Wiltshire. The travelling to and from turned out to be very tiring. I was lucky enough to only need 5 days of treatment. However, I was so exhausted by the time I came back that I needed special assistance at Southampton Airport. There are 4 points that she makes. She says, I class myself as being in relatively good health, but I was exhausted after the CT planning meeting and from the 5 days of treatment, how on earth do patients cope who are in poor health after enduring chemotherapy? 2, the waiting lists are very long for treatment in Southampton, partly down to COVID and partly down to the fact that Southampton services are a large catchment area and treat a large range of cancers. I believe that if radiotherapy could be provided on island, waiting times wouldn't be so long. 3, I'm self-employed. I already had to cancel commitments to photograph weddings last year. I had to turn down an assignment whilst I was having radiotherapy. Had I the treatment in Jersey, I would have been able to continue working. And lastly, I feel so strongly about the impact of patients having to go off island for radiotherapy that I had contacted the media, and indeed, sir, on that point, I'd like to thank Catherine, because she was, I think, the first person that contacted me about this issue to try and has been giving it, raising media awareness of the issues faced by patients who travel. She just concludes by saying, how do patients cope who have a young family, have elderly parents who are dependent on them, or simply too ill to travel? No one can put a price on the devastating impact of having to leave one's home and loved ones for treatment, just at the time when you need to be in the comfort of your own home, surrounded by those closest to you. Lastly, sir, the second one, it's not that long, sir, so members will indulge me. This is from somebody coincidentally also called Catherine. It's Mrs. Good. She doesn't mind me giving her name, sir. She said, my sister was diagnosed with breast cancer in 2012. She travelled to Southampton several times for radiotherapy treatment. She was given the all clear in 2013. Sadly, in 2015, she was diagnosed again. This time the cancer was more aggressive. Again, she had to travel to Southampton several times for treatment. I travelled with her for the first round of radiotherapy. Whilst the staff at Southampton were fantastic, as were the staff at the hotel where we stayed, it had quite a detrimental effect on her as the week went on. Being in a hotel rather than in her own home was very upsetting for her. There was nowhere for us to sit together and be quiet to cook a meal and have some privacy. For a cancer patient to have every meal in a restaurant is unrealistic. My sister could often not face going down to the restaurant and so would not eat. The return journey home was, needless to say, very difficult. Luckily, I was with her to lend a hand with luggage and travel to the airport, comforting her whilst we sat waiting for a flight. And the flight itself, she was thoroughly exhausted and in quite a lot of discomfort from the treatment. I don't know how she would have managed if she had not someone to accompany her. Further trips were undertaken. She was accompanied by a partner who had to take 6 weeks off work to stay with her, as by then she was really quite unwell. Fortunately, my sister's partner was self-employed and so had the flexibility. So I think I'll leave that one there. And what I would say is that those two accounts that I've read out really do reflect some commonalities with all of the various cases that I know of that have been in contact with me, who have had those kind of experiences. And what I would say in this is that, of course, this debate shouldn't be about whether or not we have to choose between having good and effective treatment or doing it on island. And again, this is really a scoping request that I'm putting forward, which is already in train, it has to be said, and which I think it would be helpful for the Assembly to give a steer to the Minister over, because I don't think it's a fair dichotomy to say we can either have good provision, which is cheaper and provided off island, or we can have an on-island facility which might be more expensive and which isn't going to provide a quality service. I think it's worth us looking into and aspiring to having a radiotherapy unit on island which can treat potentially up to 80% of cancer patients. I do understand, having spoken to the Minister and the specialists, that there will always be people who, for whatever reason, for complex and specialist treatments, need to go to the UK for particular treatment, and that is indeed the case across the piece for other physical treatments and operations that cannot be performed in Jersey, sir. But as a rule, we don't require people to travel for most treatments. And I would ask members how they would feel if, for example, it was routine that we required people to go to the UK for hip operations. There are a lot of people who end up getting hips, knees replaced. We know that sometimes there are long waiting lists for that, but it is done locally on island. And I'm not saying the two are comparable. Clearly, there's a lot of technical and expensive equipment that goes into radiotherapy, not to mention the staff needed to operate those systems. But there should always be, I think, a presumption in an island which is both wealthy and prides itself on a high level of autonomy to provide as many services to the population on island as it can. And indeed, I think many people have asked me this, and this isn't meant as a criticism, but if we're building a all singing, all dancing hospital with a price tag of £800 million, why on earth do we not have a radiotherapy unit built into that already for that price? That's a question which I'm sure the minister can ask, and I get asked by people, and I have been whilst preparing this proposition, sir. I would simply conclude here, so I know the other members will want to speak, and I look forward to what they have to say, but by saying that there is definitely a human cost in this which can't be underestimated. But also there is, I think, an economic cost, as we've heard. People do like to have the comfort of having their friends, family, and their physical home around them whilst they're undergoing treatment. And if you live in Southampton or in the immediate area, you can travel there during the day, probably at a comfortable time, and go back to your own home. And you can often, depending on your level of health, keep on working at the same time, as we've heard from the first Catherine, who is a photographer. She obviously had to take time off, and I've heard of people having to take 5-6 weeks off, whereas if they'd been in Jersey all that time, they could have been doing part-time work. They could have popped into the office when they felt well enough. If they were self-employed, they could have arranged their time, and that has of course an economic impact on them and on the economy, but it's also part of their esteem, a part of them trying to keep a normal life going on whilst they're about it, sir. So in concluding, sir, I also need to mention the petition that was launched by Rose Shepherd. She's the named person on the petition. She has a very similar past experience of raising a young family, finding out that she had cancer and having to go off island on a couple of different occasions for lengthy periods. And she talks about her own journey in the proposition and in the petition, sir. And I want to recognise the work that she's been doing now in that petition, in actually bringing together some of these other statements that I've read out today, albeit while she's still receiving treatment, and trying to fight for other people to have a better system in the future, so that they can receive the treatment in Jersey with all the added benefits to it, sir. So I do invite members to, I'm sure it will be a good-natured debate, sir, and I would invite members to give their thoughts on how we might do this, albeit subject to the minister's feasibility study. I do maintain the proposition, sir, and ask for a seconder.
Thank you very much, Deputy. Is the proposition seconded?
Yes, sir.
Deputy St Martin.
Thank you, sir. Not going to be an easy debate for some of us, sir. I don't have to look to constituents or other members of of Jersey for submissions, because I have my own experiences of travelling off island for cancer treatment with my late wife, be that for chemotherapy, radiotherapy, other treatments, or indeed major operations. So to say that these type of journeys can be challenging, going away for treatment in many cases is a massive understatement, especially when you have to travel through the larger London airports, things that able-bodied people take for granted, that they don't even notice they're doing, become major obstacles. Who wants to endure these issues like security and check-in and the long walk to the gate when you feel so desperately unwell? You may well be in a wheelchair or in a trolley. So we would all want to be closer to home, to have the comfort of family and the surroundings we know so well, and to have access to treatment here in Jersey. But sir, while it might be nice to have, not to have to endure a plane ride or to endure the pressure of transiting through airports, while it might be ideal to be closer to home, in my view, and in the main, that's where the niceties stop. From a purely practical point of view, how many machines would we need? There's very many different types of machines for different types of radiotherapy. You clearly couldn't have only one machine, because once you start treatment, you can't stop. And if a machine needs to be serviced, replaced, or is broken, you'd need to have more than one. On a slightly less practical issue, how many staff would we need? And where would they come from? And we know the challenges around nursing staff and recruiting at the moment. But by most importantly, sir, the question you need to ask is, do you want the best care? Do you want the best surgeons, the best consultants? Do you want the best cancer hospitals? Those who are working with this awful disease on a daily basis. Sir, we have access to literally world-class treatment in the world's top cancer hospitals, and the very top consultants see people who travel from Jersey. And while the deputy's proposition seems like a wonderful idea on paper, it for me isn't the answer. I accept that he isn't saying that all treatment would happen in Jersey and it would still be a mix. But as difficult, as awful as travelling when you feel so desperately ill is, as awful as it is to be separated from your family when you feel so down, surely we want our islanders to have the very best treatment at the very best hospitals from the very best consultants. So I'm very sorry, but I won't be able to support this today.
Very much, Deputy. Kind to St. Peter.
Thank you, sir. My late wife was treated at the radiotherapy unit in Southampton and received an excellent level of care, and I only have praise for the staff that work there. The treatment lasted approximately 5 weeks and we stayed in an apartment provided by Jersey Hospital. I was lucky to be able to support my wife throughout the treatment. However, we often thought of those people who were attending on their own, separated from family and friends. As the treatment progressed, my wife became weaker throughout the 5-week period, and in her case, I was able to assist her to get from the apartment to the car and get in and out of the vehicle itself. Had she been on her own, all the tasks would have been far more difficult and would have added to what was already a stressful situation. It's not just the physical issue arising from the treatment. We cannot forget the emotional support that someone undertaking this treatment needs. There are constant concerns about whether the treatment will be successful or not. And as the patient becomes weaker, the smallest issues are magnified and take on far more significance than they deserve. Again, I could support my wife, But those patients who attended on their own do not have that level of support, and it is simply not the same to talk to someone over the phone or by text or email. But it is not just getting people off island for curative radiotherapy. There are those who are already ill and in pain, and those receiving palliative radiotherapy who are receiving treatment to alleviate symptoms of cancer that cannot be cured. At present, access to radiotherapy for these patients is poor, as the difficulty of transport to and care for them at Southampton bring many more problems compared to those for the able-bodied. Do not all these groups deserve access to an on-island radiotherapy unit, alleviating the emotional and physical issues associated with having to travel to the UK for treatment? UK waiting times can be long, and yet the earlier treatment is undertaken, the better chance of survival the patient has. COVID certainly had an impact, and I know my wife's treatment was delayed by some months, reducing the chance of successful treatment. We should not just consider the costings, but should consider all the other benefits, some of which I've covered, when considering whether we should have our own radiotherapy unit. Remember, not giving people early access to radiotherapy when they need it is not a cost saving. I would ask members to support this proposition, which will benefit those who need radiotherapy treatment for whatever reason and will increase their chances of successful outcome. Thank you, sir.
Thank you very much. Can I tell, does any other member wish to speak on the proposition? If no other member wishes to speak on the proposition?
Yes, sir.
Well, the norm is to put a
Yeah, I
request.
know. I'm a bit slow on getting to the button, sir.
Well, I heard from you first, so I'll call on you first, Senator. Yes.
Thank you, sir. Yes, I mean, I appreciate the deputy's enthusiasm, you know, for keeping Jersey in the forefront of treatment. But as the deputy of St Martin was saying, there are a number of things we should keep in mind. According to some of the research I've seen, we'd need some 80 or 90 support staff for such a unit. And given that we're short some 300 or so skilled staff, has Deputy Teddier considered how to fill these roles? Mind you, if we reduce the number of managers back down to 12 from the 88, we might be able to afford a few more nurses. However, we are also able to utilise the facilities of a centre of excellence by using Southampton. I had a similar setup when I had my stents fitted, and I was flown to Oxford in, I don't know, about 2012. Yes, it wasn't much fun going to be away from home, but, you know, did I want a top surgeon to actually fit a stent, or did I want somebody who probably only does two in a year perhaps, or in a month, to do it? No, I'd rather have the best, thank you. And, you know, given the current state of play in HCS, with consultants resigning over the bullying and generally toxic regime, and the fact that staff are afraid to raise matters of concern, is HCS really in a position to bring in a new technique and procedures? We haven't even got a good rehabilitation unit, for heaven's sake. You know, this is a fantastic idea, but I think it must go on the back burner for now. Maybe when we've got a few things better sorted, we can actually start looking at it again. Thank you, sir.
Very much, Senator. Deputy of St. One.
Thank you, sir. So, sir, I will be supporting this proposition as amended because it, as Deputy Tadye has indicated, it would support investigations that we are currently carrying out in HCS to examine the feasibility of providing radiotherapy services in the island. So there's no firm decisions taken one way or another, but it is something that we acknowledge many islanders would wish to have, because since I became Health Minister, I have received emails from patients who have struggled, and well understand the struggles, with the arrangements made for their support in the UK centres and the travel difficulties. And I think we all acknowledge it would be desirable if we could avoid all of those. But as the amendment says, we must put patient outcomes first and foremost, and that is what we are looking to. It's a complex piece of work because we've got to examine those human needs, but at the same time we've got to examine clinical safety issues and practical issues such as the location of this, if it was to happen in Jersey, and the financing of it. So all that work is being undertaken. It began last year. Subsequently, the petition was launched, and I was pleased to respond to that. And subsequently, we have Deputy Tadye's proposition. And we recognise that this arises because there are negative impacts of delivering care off island, especially when people are coming to terms with their diagnosis and feeling ill. It's often the case they cannot travel with their relatives. It can be a very lonely time for some, and certainly affects their well-being. Some patients choose not to travel. It's just too much to bear, and they endure their illness without radiotherapy treatment. And there are palliative care patients in the island who would benefit from radiotherapy, but because of their advanced stage of illness, they are unable to travel. So we can't assist them with a therapy that we would like to offer. All of this is, those effects and impacts are well known, and I thank those who've already spoken for very clearly identifying and sharing with us the trauma that patients and families go through. And as Deputy Tadye mentioned, there are also wider family and economic costs. So very often people have to deal with childcare. How do they look after children whilst treatment is taking place, and the cost of their travel and accommodation. Deputy Tadye also mentioned that some patients are not earning when they spend long periods off island, and sometimes they could still be earning, and so that income is lost to them and the benefit to the island. But we also have to recognise that radiotherapy is a very specialist service which would not normally be available to a population of just over 100,000 people. And the centres we use provide excellent care and treatment with very good outcomes. And HCS, and through us, the island, has a good relationship with those centres. And it is the case that even if radiotherapy was to be provided in the island, there would be some patients, we estimate approximately 20% of patients, mostly with head and neck cancers, who would still need treatment off island, because that is a specialism within a specialism, and we could not provide that on the island. So I'm very clear, everyone working on this is very clear that if we take this further, we must ensure that clinical safety and the clinical outcomes that are able to be produced as a result of providing this on island must be as good as anywhere else. As good, if not better. We must have that quality, that high quality service which islanders presently enjoy. So all of that will be investigated. We'll also be investigating the workforce implications, the availability of staff and the skills that are needed, and the resilience of the unit and the backup, because yes, we will need, I understand, at least 2 machines in case one ceases to function. We need to be assured of the quality and assured of the treatment safety. All those things are being taken into account, together with considering location. Could it be up at Overdale? Could it be elsewhere on the island? It needs a very special type of power supply. We've also got to consider the demand and capacity, the capital costs and the ongoing revenue costs, because this would be expensive, but nevertheless may well be desirable. So I am keen to complete the investigation that is going on, that the work formulating a business case. I know there are clinicians in HCS that are also keen to investigate this and would really wish to bring this to the island if it were clinically safe and we could ensure those good outcomes. And we're also working closely with the cancer charities who wish to improve the experience of islanders. So in time, if a full business case is supported, it would go through the internal processes with the Treasury and would come to senior leaders and ministers, and if taken forward, could be incorporated into a future government plan. But that is not yet. That will be for the months to come, and it won't be for this assembly. It'll be for the next Council of Ministers and the next assembly. But as the proposition requests, I will be in a position to set out an options appraisal and present that to the Assembly by April as a report. And I can say amongst the options, what has been requested is that we will include an option of improved off-island treatment as an alternative to an on-island treatment, with the aim of improving the experiences and the outcomes for patients, so that if it was not possible to deliver this on island, we would want also to look at how we could better the difficult circumstances that patients and their families endure, and ensure that we can offer them the very best that we can. So I look forward to that work being undertaken. I look forward to presenting that options appraisal by April. I thank the Deputy for highlighting this issue, and I will be supporting the proposition on the basis I've outlined. Thank you, sir.
Thank you very much, Minister. The Deputy Higgins.
Thank you, sir. And I would remind members what the proposition is about. It's saying that in principle, Jersey should have its own radiotherapy unit for the treatment of cancer patients. And then it's requesting the Minister to explore the options, which he's just outlined and he's supportive of, and to present those options and recommendations to a States Assembly. It is an information gathering exercise. I think in principle, there'd be no one who would object to having a radiotherapy centre in the island. And again, until we have the full information, we won't know whether it is a sound investment and a project to embark on. Now, I have travelled to the UK for radiotherapy treatment of cancer. In the past, I spent 5 weeks at Addenbrooke's Hospital in Cambridgeshire, and I must say that the treatment I received there was absolutely fantastic. The staff were excellent, but I can see some of the problems associated with people being away. Now, I was fortunate. I was basically with another Jerseyman, the first 2 people who went to Addenbrooke's for treatment under the contract that had been established. And I was fortunate to have, in a sense, a traveling companion, someone who was going for the same treatment, was going to be there for the same period of time. And under the facilities that we had at Addenbrooke's, the States had leased an apartment that had 2 bedrooms with ensuite facilities, as well as a kitchen and a lounge area. And because we were both there having the same treatment, we got on exceptionally well. And it was, although it was not something we all desired, it was a pleasant experience. But had I been traveling alone, it might have been a different one, as it would have been for the other gentleman that I was with. Because on one particular occasion, I heard a call from him and I went to see him and he was unwell and he could not go across to the main hospital for his treatment. And I had to call 999 and arrange for an ambulance to collect him. And he was admitted to the main hospital for a number of days. Now, a person on their own may not have got a quick response as the gentleman did who I was sharing the apartment with. And there is no doubt also that when you're traveling, or sorry, I must mention the treatment itself. We all talk about the honeymoon period. The first week or so of radiotherapy is fine. And in fact, I know I personally felt like a fraud. However, as the treatment goes on, you get progressively weaker and you have various other problems. And it is useful to be able to have people nearby who will support you or can assist. So I can see the advantages of having the facility here in the island. And I can see some of the disadvantages of going away. Again, I can see the advantages of going away and getting the treatment we had with excellent staff and equipment. But I would hope that the investigation, when it goes forward, will go slightly further. We tend to look at these things in terms of our own needs. If Jersey did have this facility, and I'm not saying this as the usual thing of we could offer it to the likes of Guernsey, so instead of them going to the UK, they could come and use the Jersey facilities. We talk about health tourism. Perhaps it could be that if we have excellent facilities and we do get excellent surgeons to go along with it, can offer treatments here in the island, any spare capacity can be used for treating people from abroad, which would again bring money into the island. I'm not being mercenary in that sense, I'm just stating it as a thing to be looked at. Essentially, we should have radiotherapy facilities for the patients so they get quick treatment, which could prevent their death. So as far as I'm concerned, this is a no-brainer. Deputy Taddier is asking for an investigation and the information will come back to the States. It's at that point we can decide whether it is an excellent idea which should be funded and we should go ahead with, or it may come across that it is simply impractical and what we have at the present time is the best. But I shall be supporting this proposition and I urge all members to support it as well. Let's get the facts and then make the decision. Thank you, sir.
Very much, Deputy. Colin Harbison, John.
Thank you, and I thank the previous speaker and previous speakers to him for sharing their experiences. I'm sure all of us have been touched by this dreadful disease over the years. Local patients have had excellent care at Southampton for decades, and as we've just heard from Addenbrooke's. As someone who used to travel to Southampton on a weekly basis for work, sir, I can tell you I've seen many, many patients travelling to and from Southampton in all kinds of conditions. And if we can reduce that prospect, I think that would be great. So I'm surprised that the amendment didn't ask for more time, because I'm concerned that we've got a department that appears to be under a lot of pressure, and I share Senator Fergus' concerns. There are 353 vacancies in the last number we've had from HCS. I'm surprised they didn't ask for more time, because back in October 2019, the JEP reported that more radiotherapy could be done locally, and here we're going to have a business case within a matter of days put forward. I just hope that it's a full business case, and I hope that it's going to be considering all those options, including those described by Deputy Higgins. Only today, sir, I've been communicating with a parishioner who's having treatment in the UK, and this person had put off treatment for around 5 years. And part of the reason for putting off the treatment was because they didn't want to travel to the UK to receive it. If we're able to overcome the many practical issues and it's affordable, then we should seriously consider this. I agree with the Minister, the safety, the clinical safety has got to be correct and the outcomes need to be monitored. But if we can do it, sir, let's see the appraisal and the recommendations, and I'd urge members to support the proposition.
Point of clarification, Deputy St John? Would you give way for point of clarification?
Yes, sir.
Deputy St John? I beg your pardon, Deputy St John, yes.
Thank you, sir. Could the Connétable confirm that he understands the proposition is asking me to present an options appraisal? When I spoke about the business case, I hope I made clear that that was a different and larger piece of work which would go through the process required by business cases and be a matter for the next assembly. Thank you, sir.
Yes, sir. My apologies. It is a full options appraisal and recommendations. Thank you.
Very well. Does any other member wish to speak on the proposition? If no other member wishes to speak, Deputy St Peter.
Thank you, sir. Like many people in the Assembly, we've all had friends and family who have had to undergo radiotherapy in the UK. And when I was honoured to be put on our hospital political oversight group, those that are on the group will know that I banged the drum for radiotherapy almost every single meeting. I'm now not so sure. It is a very complex subject, and I won't bore you with what I've learned because that will come out. However, I really do welcome this initiative in order to truly understand the options that are available to us, so we can make an informed based decision. Now, what I really want to talk about is, regardless of the outcome, 20% of people will have to travel abroad or to the UK for treatment. What I've witnessed in those people, and it's been covered, and I'm doing a little bit of repetition, is there is so much more we can do to make that experience not as unbearable, if that is an awful way of putting it. Be it helping with travel, being allowed partners to travel, improving the accommodation that people can stay in, flying them back at weekends. I know we got trouble with fog and they won't be able to get back for the next treatment on the Monday. But of all these things we could do, that is where we can help, I think, in the most. And I just urge the Minister and those people who are doing this options appraisal to look at that most seriously and see how well we can help those people who have to undergo treatment in the UK. It is quite clear it is outcomes based, and the experts that are at disposal. One of the people I was referring to was at the Marsden Hospital, which hasn't been mentioned yet. I know we tap into every source of expertise we can in the UK to ensure we get the best outcomes for people. That must continue, regardless whether it's locally or in the England. But look at the travel, look at the accommodation, look at the way we can just make it more palatable for those people who have to undertake the treatment. Thank you, sir.
Very much, Deputy. Does any other member wish to speak on the proposition? No other member wishes to speak. Then I close the debate and call upon Deputy Tadier to respond.
Thank you, sir. I thank the members who have spoken. I think it was probably a shorter debate than I anticipated, but I think we covered a lot of ground nonetheless. So the first speaker was the Deputy of St Martin, and I respect his point of view. I have to say, I think what I'm proposing here, or what's being asked for from the 3,000 plus petitioners who have signed, and I think also what the Minister himself agrees is the position he would like to be in, subject to the feasibility and options paper that he's working on, is that this is much more than a nice to have. This is about people's lives, and it's about, I think, also not just those who currently travel. And it's easy to say, well, you know, okay, they might have to get up a bit early. They might be taking a few weeks off work and away from their family for a few days or a few weeks in some cases. But, you know, they should just put up with that if it's saving their lives. And I think that's one thing that I wouldn't say. But there are also a great number of people that we don't know about who simply don't travel and therefore don't receive the treatment for whatever reason, because we don't have an on-island facility. And it's those people that I'm also thinking about. So like other members in the Assembly, I know what it is like to have loved ones taken away from me because of cancer. I lost both of my parents to cancer, and in those cases it was fairly late. It was very late diagnoses, and there was no chance of treatment. And that's always a double-edged sword, sir. And I know that that's probably the way they would have wanted to go. But I can only think about if this had been caught earlier, and the many people who do have earlier diagnoses, even a bit earlier, that they're given the option. In fact, I do remember 5-6 years ago when we were having conversations with my father, and he said, no, I don't want to receive any treatment. And I know that there'll be other people who might be more marginal than that. They might be caught slightly earlier, and they might say, well, actually, no, I'm not prepared to go and travel. I'm not prepared to have all that upheaval to go and receive, to roll the dice about potentially saving and extending my life. And if the facility were available on island, I would quite happily do that. But I'm not going to go through weeks of upset and trauma for my family for something that I don't fully know the outcome of. And something I forgot to mention in the opening, but which relates to that point, is that in terms of palliative care, that there isn't any option for radiotherapy for palliative care on island, and it is not offered to patients who have palliative needs. And of course, as we know, palliative doesn't automatically mean it's your end of life. It just might mean that it's not curable. And there are lots of people in that situation, even young people, but across the spectrum, who are in that palliative context, and who are unable to travel, sir. And it's also those people who I'm thinking of in that number, sir. So whilst we talk about the 20% who will still need to travel, we're talking potentially about another 20% or however many on island that are there's a latent need for them, and that they would use this facility, sir. We didn't hear from the other Progress Party member, and I'm not sure if this is a party position, sir, but I would ask the member to reconsider perhaps how he votes, because I think this is really asking for the work to be done to look at options for delivering this, sir. Similarly, the proposition doesn't say that Jersey should have a substandard radiotherapy unit, and if we are to have one, I don't quite get these arguments. Is that the radiotherapy equipment will either work or it won't work? It's not as if we're going to set up an expensive unit, buy 2 pieces of equipment and not calibrate them properly. So whatever they use, the lasers, the radiotherapy rather, which will be targeting certain key areas of the body, of course they will be calibrated. And to talk about staff implications, this of course will be looked at in the study by the minister. But I would say 2 things: that there is an option nowadays for specialists, perhaps in part at least, to operate equipment remotely. That's what I've been told from officers. And I can't remember if Senator Ferguson talked about 85 staff needed to operate this, or 65 staff. I think those figures are probably fantastical, but I would also say that staff at the hospital tend to be polyvalent. They don't necessarily just specialise in one area, but they often will work in different areas. So that will all come out in part B of the proposition, sir. There is also the work that charities do in Jersey that needs to be taken into account when the minister talks about what I might term as opportunity costs, about the blue sky thinking and about what might happen in terms of the positives. So if we had an on-island provision, we would want that to be excellent, and we would want that to be responsive and to be used and possibly shared with the sister island. I don't think, though, sir, that this should be predicated on Guernsey buying into this. I really think it is a case of build it and they will join us, because it makes more sense for Guernsey to fly patients to Jersey, that small distance across the sea, rather than to rely on scheduled flights to Southampton, sir. But that's a discussion for another day. So I do thank the minister for his amendment and for his support. I think he's open-minded. And to address the Constable of St John, I did also ask the minister quite explicitly when I met him last week, are you sure this is enough time to do this? If you want to, you can have more time. I'm aware that the minister wants to report back to this assembly before the end of this term, and that we only have sittings until the end of April. The minister believes, and the staff, his officers believe, that they can report back something meaningful and present an options paper for members to consider. And I did say to the minister that I hope it's a proper open-minded consideration, and it's not just simply a case of the computer says no, we've looked at the options, it's too expensive, it's not feasible. I think it's important that we do consider all of the costs, both the human costs, the savings, and what future spending we might need. So cancer isn't going to go away. I genuinely hope that it will, and that we might find a cure for it someday. And as technology and medication progresses, of course, we all hope that, sir. But we also know that it seems that for the time being, and this is what the specialists have told me, I speak to them, is that it's here to stay, certainly, unless something really good happens, and that we need to start thinking about how we best cater for people on island. So I believe firmly that this should be part of the new care model. It should be something that we look to provide for on island for the vast majority of our patients. And so I do ask members for their support to allow the minister and give him a signal that this is something that we would like, unless there are very compelling reasons for it not to be achievable. So the minister still has that wiggle room, and he will be reporting back to this assembly, and it is something that will be watched, I think, very closely by members of our community who this either currently affects or will affect in the future, sir. I'll be asking for it to be taken together, sir. I think all three parts are contingent, and I maintain the proposition.
Very much indeed. I ask the referee to place a vote into the link. Vote is on P113. I open the voting and ask members to vote.
So that's taken a while to come through, just to say, sorry. I think it's soon out. Apologies.
If members have the opportunity of casting their votes, then I ask the greffier to close the voting. Proposition has been adopted, 38 votes pour, 1 vote contre, 2 abstentions in the link, and a further 2 votes pour in the chat.
So can we have the contra and the
Yes.
abstention, please?
The Deputy of St Martin and the Connotab of St Clement abstained, and Senator Pallett voted contra.
Very well. The next item is the draft official controls animals, food, feed and plant health, etc. Jersey Regulations P114, lodged by the Minister for the Environment, and I ask the greffier to read the citation.
Draft official controls animals, food, feed and plant health, etc. Jersey Regulations 2000. The states make these regulations under Articles 2, 5A and 5B of the European Union legislation implementation Jersey Law 2014.
Minister.
Thank you, sir.
Sir, if Deputy Guida could be rapporteur, please, sir. Thank you.
Certainly, yes.
Thank you, sir. These regulations form part of our continued response to a post-Brexit world to ensure that the island has the necessary frameworks in place as an importer and where necessary as an exporter of goods. I would like to start this by thanking all the officers who have helped put this together. This has been compared to solving a Rubik's Cube whose color labels had been replaced by disco lights. It wasn't straightforward. In a practical sense, these changes are intended to mirror those brought into UK legislation to accommodate the border changes born from Brexit. These regulations, if adopted, would repeal and replace the EU legislation Official Controls Jersey Regulations 2020 and the Animal Health and Welfare Temporary Continuance of Effect of European Union's legislation Jersey Order 2019. The main change that would arise from these regulations would be to allow the Minister, as a competent authority, to treat goods entering Jersey from the rest of the world differently to goods entering Jersey from the UK. It would also provide for the Minister to determine how controls are applied, including via the use of possible border control posts to SPS goods entering Jersey from the EU. There are 6 other regulatory changes which are identified in full in the report accompanying the proposition. In summary, these cover food safety, genetically modified organisms, maximum residue levels of pesticides, contaminants and pharmacological active substances, and microbiological criteria. The Environment, Housing and Infrastructure Scrutiny Panel presented a comprehensive set of comments on the proposition, which included, among others, 2 important recommendations, which we will be happy to implement. As the panel recommends, we will ensure that clear and multilingual guidance is made available, and we will provide documentation to aid traders' understanding of any new requirement placed upon them, both as soon as practically possible. Returning to the panel's comments more generally, the panel noted that these regulations are a necessary requirement, but that they are mindful that there is uncertainty as to the potential impacts the post-Brexit regime will have on industry. I can confirm that government recognizes this too, and will, with the assistance of scrutiny, continue to liaise with key stakeholders to ensure that they understand and are able to meet their legal requirements. Furthermore, together, we will ensure that assistance, where possible, is made available to them. I trust that the Assembly will share the view of both the government and scrutiny that these regulations are necessary and that they form part of the island's ongoing response to Brexit. Sir, I would like to open the debate to the Chamber and trust that I will be in a position to answer members' questions.
Very much, Deputy. Are the principles seconded?
Yes.
Any member wish to speak on the principles? Going to Arbor St. Brelard.
Thank you, sir. The Minister has wrapped up pretty well what my panel submitted in its comments, and I would refer members to those comments. It is a complex process, as the Minister outlined. We have been pleased to work with the Minister and his officers to try and understand the process which will need to be taking place as a result of Brexit and continuing trade with the UK and indeed the EU. We thank the Minister for accepting our recommendations and will be supporting the proposition. So thank you
very much, Colonel Does any other member wish to speak on the principles? No other member? Deputy Ward.
Thank you, sir. It's really a question for the Minister. And if I'm off the mark here, then please politely tell me that, because this is, you're right, it's absolutely complex. I've always had a concern since day one, when I was on the Brexit panel and we looked at so much, that one of the issues that we'll face is that as the UK has more treaties and independently with different jurisdictions around the world, the classic one is, for example, with the US, where perhaps food and regulations are less stringent. In fact, they have other things in their food chain that perhaps we wouldn't want. And we move closer to the UK. What is here to sort of give controls for Jersey that perhaps won't be in the UK? If the UK starts to import food and products, and particularly genetically engineered products, of which I don't necessarily have a problem with, because that's a much wider field, does Jersey still have that control over what it imports, or will we inevitably have to accept imports because we are so close in with the UK, and the UK could move further away from Europe depending on what happens in the coming years with the implications of Brexit? I just want to, I know there's not a simple answer to that, and I'm not expecting the Minister to go into detail in that way, but I just wanted some reassurance that we do have that ability to take consideration over those things, because that does concern me, that the removal of regulations of food, plants, and et cetera, as we go forward. Thank you, sir. I hope that makes sense for the Minister.
Thank you very much. Any other member wish to speak on the principles? If no other member wishes to speak on the principles, I close the debate and call upon the Deputy Leader to respond.
Thank you, sir. I would like to thank Constable of St. Brelard for his support and support for his panel. To Deputy Ward, these are perfectly valid concerns, and they are a difficulty for Jersey. However, we have tried to build as much flexibility in our controls as possible. So we can diverge a little bit from the UK, but of course we have a free trade agreement with them, and we also have to abide to World Trade Organization rules. One way that we can help with this is by requiring food labeling that would allow people to make their own choices. So there are ways. We do have some flexibility, but it is indeed quite difficult to diverge too far from what the UK wants to do with other countries. Every time the UK, one thing, and that's more of an external relation issue, but every time that the UK looks to have a trade agreement with a third party, we are asked in which way we want to participate. And we do have this option in the Assembly on how we want to follow the UK every single time. I don't think there was anything else. So I would commend the proposition to the Assembly and ask for the appeal.
Ask the Greffier please to post a voting link into the chat. I open the voting and ask members to vote.
Sorry, I am voting for, please.
Oh, is that Members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. Principles have been adopted. 38 votes pour, no votes contre, no abstentions within the link, and a further 3 votes noted pour in either the chat or in the assembly. Connétable and Brillard, I take it your panel's not calling the matter in?
No, thank you, sir.
How do you wish to deal with the matter in second reading, Deputy Guida?
I would prefer to take all the articles en bloc. I don't think any of them can be separated and still have a functional regulation.
Do you want to just propose them, or are you speaking to them?
I will propose them, but of course, if any members wish to ask a question about a specific article, I am happy to respond.
Very well. Are they seconded in second reading? Does any member wish to speak on the articles or any of them in second reading? If no member wishes to speak, Deputy Ward.
Thank you, sir. I think I'm not sure this is anything. I recognise that our hands are somewhat tied with these with Brexit. In Article 12, power to make provision by order, in Part 1, it says the Minister may make provision by order, make provision as is necessary to give effect to that empowering provision in Jersey, and any regulation requires the Commission of the European Union. So is that our way of adopting European Union regulations that make movement of goods from Europe smoother? And then later on, no, I think that's the question really. It's just understanding those power to make provision by order and whether that would enable us to have that bit more flexibility that the Minister spoke about. Thank you so much.
Very much. Does any other member wish to speak in second reading? If no other member wishes to speak in second reading, then I close the debate and call upon the Minister to respond.
Yes, sir. This is quite interesting. From the beginning, the whole Assembly decided that we would try to stick to EU regulations as much as possible, as well as UK regulations. We will see what happens if they start diverging. But of course, the main goal was to remain compatible with the EU. Of course, the EU may change their own regulations at any time, and this allows the Minister to follow them if this is what Jersey wants to do.
Very well. Ask the greffier to place a vote into the link. And I open the voting and ask members to vote. If members have had the opportunity of casting their votes, then I ask the greffier to close the voting. Regulations have been adopted in second reading, 41 votes for, no votes contra, no abstentions in the link, and a further 1 vote pour in the chat. Do you propose the regulations in third reading?
Yes, sir, please.
Are they seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? If no member wishes to speak in third reading, then I close the debate and ask the greffier to place a vote into the link. I open the voting and ask members to vote. Members have had the opportunity of casting their votes. And I ask the greffier to close the voting. Regulations have been adopted in third reading, 38 votes pour, no votes contra, no abstentions in the link, and a further 2 votes noted pour in the chat. Very well. The next item is the Common Population Policy, P116, lodged by the Council of Ministers, and I ask the greffier to read the proposition.
The states are asked to decide whether they are of opinion, A, to adopt the inaugural Common Population Policy for Jersey as set out in the accompanying report, and B, to request that the Council of Ministers should include its policy on population in future government plans from 2023 onwards.
Senator Farnham, are you presenting this?
Thank you, sir. Deputy Hewlin is rapporteur for this item. Thank you.
Very well. Deputy St. Peter.
Deputy St. Peter, I should say.
Yes,
Thank you, sir.
yes, indeed. Indeed.
Sir, I think we're all in agreement that Jersey needs a population policy, but there's little consensus regarding what that policy should look like. Over the last few months, I have repeatedly used a simple Venn diagram to illustrate the essence of the population policy as I see it. The Venn diagram shows 3 overlapping circles representing the economy, the community, and the environment. Population sits at the intersection of those 3 circles. A successful population policy will balance the needs of the economy, the needs of the community, and the needs of the environment. As our written report explains, this is no easy task, and we have no easy answers. During our extensive consultation last year, I listened to and read views of hundreds of islanders. Business owners are worried about staff shortages and want the policy to guarantee them access to more staff. Environmental organisations are worried about damage to the environment and the loss of green spaces and want the policy to restrict inward migration. Community groups are less worried about the level of migration, but want the policy to provide an inclusive and welcoming community for migrants to be part of. Many people who have lived in Jersey for a long time yearn for the good old days and quite simply think we should not allow any further population growth. This report makes it very clear that to maintain the balance between economy, community and environment, we all need to act together and we need to plan carefully, protect all three areas as we work together to bring down migration levels. Up front, I want to address the issues of delay. I'm not interested in hanging around and just talking. Under my direction, a new IT systems to manage improved migration controls has been designed and developed. A complete review of the Control on Housing and Work Law has been completed and extensive amendments lodged for debate next month. Without a functioning IT system, without a flexible law, any attempt to set population policy will not be worth the paper it's written on. COVID means we are behind where we would like to be, but significant actions have already been taken. There has been criticism in some quarters that this policy puts off decision-making for 4 years. This criticism is completely unfounded. This policy lists 44 tangible actions identified for 2022 and a wide range of proposed areas for the next Council of Ministers to take forward. We are already taking action and must continue to do so this year, next year and every year. Members need to be very clear that any actions we might take with the aim of reducing net migration are going to have consequences for the island. Putting it bluntly, if we don't take steps to create the robust framework that we need, and if we don't encourage the growth of a sustainable workforce, and if we don't have the controls in place to respond flexibly to current challenges, we will upset the balance between the economy, the community, and the environment. And that is what, as a risk, we cannot afford to take. I'll give members an example. Many people have urged me to impose strict migration controls immediately, with businesses only able to recruit new or replacement staff from overseas under very tight controls. This kind of strong action from the government would be welcomed by some of the strident voices we hear in the local media, but business confidence would plummet. There would be very real risk of long-lasting damage to our economy and the drop in government revenues that would lead to declining health and education provision. We've also seen the opposite argument in the press over the weekend. A shroud-waving statement from the Chamber of Commerce that unless the government continues to allow businesses to bring in more migrants, the island faces disaster. I do not need to spell out the consequences of inward migration continuing at recent levels. The pressures on housing and the environment will continue to grow and will only get worse in future years. So, sir, what to do? I firmly believe that the plan we have set out will move us towards the balance that is so important for the future of Jersey. Change will take time, and sudden changes in policy are likely to be counterproductive. Change will only happen if individual people, businesses, and the government all work together. Change must be sustained over the long term and needs firm foundations to build on. The actions set out today are grouped into 3 key areas where change is needed. Proactively creating a sustainable local economy built on a well-trained and engaged local workforce. Implementing flexible and responsive migration controls to manage the flow of migrants. Basing decisions on detailed and relevant local and international information. I'll look at each briefly. To control the population and maintain a vibrant economy, we must take planned and proactive steps to become more self-reliant as a community. We need to improve our skills training, make the most of the workers already in the labour force, improve our education system to prepare our children for fulfilling work in years to come, improve the productivity of our local industries to provide a good living to individuals and good services for the community, and improve labour market participation to help everybody play their part in Jersey's prosperity. This first common population policy identifies the actions that we're already taking and are planning to take in all these areas. I'm grateful for the Minister of Children and Education, the Minister of Economic Development, Tourism, Sport and Culture, and the Minister for Social Security for the initiatives they are leading in their portfolios. And while we improve the ability of the local population to take on well-paid and sustainable jobs, we must almost improve the way that migration controls are exercised. I will not dwell in detail on that aspect today, as members will be aware that the Chief Minister has lodged extensive amendments to the Control of Housing and Work Law, which we will debate next month. At this point, I would just remind members that the Assembly has already agreed to remove the concept of automatic graduation from the existing migration controls and to create short, medium and long-term permissions, which will allow the government to exercise more responsive controls on the flow of migrants in and out of the island. Members will also be aware of the impact of Brexit on the recruitment of staff from outside the common travel area. It will take some time for the new UK and UK immigration rules to settle down to the new situation, and I'm grateful to the Minister for Home Affairs and to the Chief Minister and their teams for their work in this area to ensure that we have close alignment between future immigration and migration systems. So, if any of your staff are running a sweepstake on how long it would take me to mention the importance of IT systems and data, I'm over 1,000 words in, but finally here it is. Today, the government would struggle to implement migration controls that were significantly tighter than those currently in force. This is because we don't have the information to fully understand the drivers behind the economy, the numbers of specialist staff that need to be employed to maintain our vital public services, the impact of skills training on vacancy levels, the pipeline of young local apprentices moving into the workforce, etc., etc., etc. Crucially, the government does not have enough data to include any meaningful numeric target or cap in this first common population policy, and I have been criticised for failing to include a number limit in this proposition. So what number would you have me choose? Today, I don't believe anybody knows how fast or how far we can reduce net migration. If any member would like to put forward a number and show me the evidence to back it up, I would be very interested. I have been involved with migration issues for nearly 3 years and have not yet seen any credible analysis that supports a particular target. Previous governments have fallen into this trap several times before, set an arbitrary limit which is then impossible to meet. Confidence in the policy is then lost and migration continues apace. If, as an island, we want to get a position where a meaningful target can be set, we must collect more data, more often. The public will then be able to hold ministers to account for the decisions they take and the limits they set. There is much good work being done in this area, but also much more to do. This first population policy sets out in some detail the new systems we are in the process of introducing to improve the basis on which we make important decisions in future. Deputy Pershaw's proposition P120 from 2020 also emphasised the need for robust data to deliver a common population policy. The Deputy's proposition requested detailed data across the infrastructure, education, health, environment and social needs of the population looking forward several decades into the future. Members will note that not all these data sets are included in the draft Common Population Policy and that they are being asked to approve today, for the simple reason we do not have the information needed to make meaningful forecasts in these areas. Better data will come on stream over the next couple of years, and this will inform the long-term planning that will be an essential part of any successful population policy. In this area, I'm grateful to the support of the Ministers of Environment, Infrastructure, Health and Housing, who also have a keen interest in planning forwards over many years. So, since the Chief Minister asked me to lead population work in late 2020, I have consistently maintained that the Common Population Policy must not be a document that, once adopted, was then consigned to a shelf and never referred to again. That is why, in September last year, we brought forward P77/2021, an amendment to the States of Jersey Law 2005, which means it's now a statutory obligation for each council of ministers to agree a common policy position on population on a regular basis and at least once a year. This first common population policy adds a further obligation to that introduced in the States of Jersey Law Amendment and proposes that the common population policy should form part of the government plan process, beginning when the next council of ministers agrees its common strategic policies, followed by the 2023 government plan later this year. This will ensure that population continues, quite rightly, to be front and centre in government strategic thinking and the development of future policy. Before I close, I'd like to thank the Migration and Population Review Panel for their detailed work on the population and migration policies to date. Their latest report was published last week and contains much useful information and analysis. Whilst almost all of their reasoning is clear and well evidenced, there's one area I believe that they might not have fully understood the thrust of the draft policy. So it may be helpful for me to address this misconception now. The policy has an overarching aim of progressively reducing Jersey's reliance on inward migration in order to achieve population stability. On page 10 of the report, the policy acknowledges that challenges may arise which force governments to pause this strategy in the short term, and this has been interpreted, incorrectly in my view, to mean that future governments can choose to ignore the primary objective of reducing reliance on net inward migration in the long term. I need to reassure members that this is simply not the case. If we've learned anything in the last 2 years, it is that we need to be agile, take tough decisions and change course if necessary, but the primary aim to reduce reliance on inward migration must remain. This is why a regularly updated population policy, if members support this proposition, will become a fundamental part in every government plan. I have maintained throughout that there's no easy solution to managing Jersey's population, but manage it we must. So the important difference today is that we have taken the time to research these issues, consult with businesses and other interested islanders, and propose an informed course of action, which is, by necessity, the first step towards achieving a stable population we all know is right for Jersey. Sir, I make the proposition.
Right, is the proposition seconded?
Yes, sir.
Yes. Any member wish to speak on the proposition? If no member wishes to speak on the proposition?
Yes, please, sir.
You'd like to the Connaught Arbison Brillard, yes? Indicated first, then Deputy Ward after you. Connaught Arbison Brillard.
Thank you, sir. And I think it's incumbent on us to comment on the significant amount of work which has been produced. Clearly, this is a matter which forms much discussion on the street, and I'm pleased that there is a presentation which will achieve to some measure what people are wanting. It's probably a little bit looser than most would like, but within the realms of possibility, it's probably all we can sensibly achieve at the moment. I would really, in summary, just thank the Deputy of St. Peter and particularly the team supporting him for producing this. It's taken a long time. I think we need it, and I look forward to it being developed in future years.
Thank you very much. Connaught Deputy Ward.
Thank you, sir. I was going to speak later. I'm interested to see what other members have to say before I put my 10 penneth in. But here we go. So I'm afraid I have to start on a negative, but I will be looking for positive elements in this proposition because we do need to address population. There's no denying that. But the negative, sir, is simple. This is really not a population policy. It's a collection of phrases, graphics, and something referred to as data and generic ideas that has no actual real notion of implementation behind it. We are being asked to adopt a policy as set out in a report. So I can't help thinking that it shouldn't have had a P number before it. It should have had an R. It should be an R number. This is a report. And I'm really struggling to get my head around what it is that we're going to adopt as policy. We've been asked to adopt a policy as set out in the report and to request the Council of Ministers to adopt this report approach from 2023, whatever that approach is. So we have a combination of vague and uncommitting language and a 120-page report that's what it calls clear principles. And so I'd like to quote from the report to try and explain the difficulty you have with what a clear principle is. And this is one of the paragraphs. Within the long-term aim of reducing reliance on continued migration, the government will always face new challenges, and there may be situations in which the long-term aim of reducing the need for net migration will need to be paused or even reversed in order to address specific challenges from time to time. Notwithstanding any such temporary challenges, the underlying principle and vision remains a long-term reduction in reliance on network migration. So there is no time scale, and the aim can be dropped at any time, and it can be completely the reverse of what the aim is if we want it to be. So that is not a policy. That's just a whatever happens, happens. And I'm struggling to know what we're voting for given that circumstance. So it seems that the current government have principles, but if they don't work, they can just find another set of principles. And to me, sir, principles are not interchangeable in that way. There has to be a principle behind it. Call me a principled individual if you want, sir, and I'd be very proud to be called that. But then they want us to endorse this reversal of principles at whatever will by this entire assembly, and I'm struggling with that. I've got to say, I'm not clear, and I think other members are unsure as to what we're voting for as actual policy. And there's this, sir. It says, however, whilst the target for population growth does not form part of the first common policy, much government activity requires forward planning, and estimates of future population levels are often used by governments and included in this planning. So that's remarkable. There is no target for population growth, but we will use data that will estimate on population growth in order to make future population levels decisions about population growth. So we're getting into circularity, which is just really quite remarkable. And I think what we've got here, and I hope this is parliamentary, but it's a word salad, a huge word salad of astronomical proportions. And there's more. Let's say this first bit with a straight face. Let's do this properly. However, assuming successful adoptions, I can't even say it. Let's start again, sir. However, assuming successful adoption of planned IT systems, there we go, and subsequent collection and analysis of data, the government should be in a position to forecast the date on which the island will be able to reach a stable population position towards the end of the next electoral cycle. That's in the report. That's what we're voting for. We should at some time in the future be able to forecast at some point towards the next election cycle a stable population position. And that is a policy that we're voting on today. Let's get this clear. So the government in the last 4 years has achieved nothing in understanding the population of this island, and indeed, it has failed to come up with income distribution surveys to absolutely understand the reality of people's lives on this island. But with an election coming up, it must give some impression of doing something about population. And within this rather poor document is a plan to do the same thing in the next assembly, with the forecast for a stable position towards the end of that time. So not only is this doing nothing now, but it's also doing nothing in the next term. And I think we need to look at this as a proposition. This is a proposition that's coming to this assembly for us to act. Where are the actions? The actions are to wait until the end of the next assembly. Sorry, it doesn't work. Therefore, so the aim of balancing the intersection of the Venn diagram, which is, I don't think the way Venn diagrams work, to be honest, is both a long way off and there's no clarity on how it will happen. So to be quite frank, this is a document that Samuel Beckett would be proud of. I think the French is en attendant de politique de population, or waiting for a population policy. Nothing to be done. So voting for this is a green light for generic phrases, strap lines, and I have to say, a support for inaction. This is not what we need right now. We need some clear guidelines on where we're going, some clear understanding of the challenges that face us now, in the next 2 years, in the next 4 years, and over the next 10 years. And this policy, and I don't know where the 64 actions are. There's a lot of talk about things that are happening, such as the education reform program, which we still don't know what's going to happen with that. We don't have the spending review. We don't have the inclusion review. We don't have a strategy on training. We have no, there was a plan for a sixth form college, but that's gone out the window. So I don't know where we are with that. And so what we've got is this melange of nothingness, which we are being asked to vote on. And forgive me, but I'm afraid I cannot, and I do not believe this is useful for us as an assembly, as an island, or will actually get anything done. And worse than that, sir, and this is the worst thing, that it will give the semblance of something happening, the semblance of something being addressed when we are not. As we enter into an election campaign where the most important one for many, many years, where clarity and honesty about what we're going to actually do is so vital. So I'm sorry, sir, I'm afraid I have a huge problem with this as a policy. And I will struggle to vote for this because, to be quite frank, sir, there is nothing to vote for. And so, sir, I ask members to consider this themselves in the same way. And I'm not going to say to you, vote for it or don't, because I don't know what you're voting for. So but please consider, I would suggest this to finish. Consider what it is that you're actually voting for. And if you can tell me what that is, I'll be very pleased. You know, pop me an email. Thank you, sir. I finished there.
Thank you very much, Deputies. Any other member wish to speak on the proposition? Deputy Guida.
So it's quite interesting because when Deputy Yulin presented this to the Council of Ministers, I took him aside and I said, this is not good. Superb report, tons of stuff in it. But are you sure you cannot put a number in it, you know, nice population number and a good date, and say by 2025, 2027, we'll have 115,000 people in the island and that's it, and that we can do that? I said, yeah, that's a good idea. That will look so much better on the papers. And then he came back and he said, no, I'm sorry. That's not what our research has shown. What our research has shown is that it is a massively complex problem that it will take everything that the government does to stabilize the population. And as we don't know either which figures to aim for reasonably or when we can achieve it. And I must say, I was a little bit upset that he had the courage to just say, well, sorry, I don't know, I cannot know, and I'm going to say it, instead of picking a figure out of his head and just say, well, that will do for the JEP. So yes, this is not the document that people would have liked to see, but this is the document that we can produce, the document that is true today. Thank you, sir.
Very much, Deputy. Any other member wish to speak on the proposition? No other member wishes to speak on the proposition? Senator Pallett.
Thank you, sir. I'll try not to take too long. Where do I start? I hope people have had the opportunity to read the scrutiny report. I've got to say we had a good relationship with Deputy Hewlin and the officers all the way through the review, and also during the review of the migration controls. And we're currently got a good relationship with the officers in regards to the Control of Housing and Work Law amendments, which have yet to come to the Assembly. But we have worked hard to try to accommodate the the deputy and his officers and understand what they're trying to achieve. So it's important to realise that we haven't come at this with a negative mindset. We very much come with it in terms of trying to be positive, as people have said, and try to understand what government are trying to achieve. Deputy Guida says it's a massively complex area problem, and that is true. But I think with any massively complex area, it does need. I think government needed to focus on it and need to focus on it early. And I think if there's one of the criticisms we've had, it maybe hasn't had the focus it needs to be able to provide something that Deputy Ward, I think, would want to see at this late stage of a political term. I think there's been a general acceptance that forecasts should be informed by robust data, but the common population policy doesn't tackle really the challenging issues that it raises. It leaves difficult decision making at any commitment to action to future governments, and no government can commit a future government to doing anything. It can suggest and provide potential ways forward, but we have to realise that that this policy very much pushes the decision making into the not just this government, but not just the next government, but potentially into the government after that. The view that we've taken is that this policy actually doesn't constitute a policy. It is aspirational. It doesn't provide the action expected by the community, or I suspect by many of the people in this assembly. Submissions made to the Migration and Population Review Panel, of which are on the website, expressed disappointment and frustration with the lack of action taken and what's actually being proposed. It doesn't fulfil the commitments made by the States Assembly, and it doesn't provide any forecast for population planning, and it does not provide any certainty for the community. Now, I know that Guida said, well, you know, why he asked why the number wasn't put in this, but there are assumptions within this policy that have been used for other government policies, such as the Bridging Island Plan. So there was opportunities to potentially use some of those assumptions in putting together a policy that actually provided a figure or a number for the island to work towards, and to give certainty to business and islands that we were trying to achieve or reduce our reliance on inward migration. It's already been mentioned around, in fact, it was mentioned by the by Deputy Hewlin around the misconception that apparently the panel made in regards to second of the principles that are in the report. I mean, again, it's very much around how you view what those words mean. But I think any opportunity that will allow a future government to pause or even reverse the policy has to be taken with caution. And I think that's the view that the review panel has taken, and that's why it made the recommendation that it has within the report, that it does give a get out clause to future governments, and I don't think that should be there. If we have targets, that should be met, and there shouldn't be ways, there shouldn't be opportunities to shy away and back away from that. In fact, as I've said, the second principle of the Common Population Policy, we believe, needs to be reconsidered, and that's one of the recommendations. I think what's clear from this, and the Deputy Hewlin mentioned it, is P120 from Deputy Pershard. Population policy, in our view, does not meet the commitments that were made as a result of the state's approval of P120. P120 demonstrated the importance that the States Assembly attached to consistent and robust planning assumptions which would underpin decision making and provision of services. The panels recommended that the principles of that proposition are revisited so that the commitments approved by the States Assembly are included in the production of a common population policy. This common population policy doesn't draw conclusions from the issues raised during the in-committee debate held on 24th of March 2021, and in our view doesn't advance the debate on population issues. Again, it's been mentioned around the new IT system and the lack of robust data. As much as that may be true, and that's up to members to make their own decisions about whether that's a necessary flaw in this policy, is the fact that government's known there's been a lack of robust data for some considerable time. Chamber of Commerce made them aware of it, yet we still haven't got an IT system in place. It's still being implemented by the government to provide them with the information that they'll need, not just for providing information for the population policy, but also for the migration controls. So it's a disappointment that it's been delayed yet again, and again it leaves the next government in a quandary, because they're the ones that are going to have to pick up not just on the introduction of an IT system, but also in looking at that data and deciding how they're going to implement not just a common population policy, but any future migration controls. I'm almost tempted to stop there, sir, because I'm sure members have read the report, and I think the views of the panel have been quite clear. The report very much, the policy was very much around stating that the government wanted to act now. There's nothing in this policy that allows them to act now. There is a lot of it around providing data, providing information around how training and education should be provided in the future. But what it doesn't do, it doesn't give any certainty to how we are going to control migration moving forward. And that's something that future governments are going to have to pick up. I haven't personally made a choice about whether I can support this today. I very much wanted to hear what other members have got to say around the policy, and I think my own fellow panel members probably feel the same. But before I finish, I do want to just thank my panel members, because we've had to work in an extremely short time frame to put together the scrutiny report. So I want to thank them, and I want to thank the officers for their really conscientious work in a very short time frame to be able to put what we believe is a report that gives the Assembly, I think, a flavour of what we believe is within this common population policy. And finally, it'd be wrong for me not to thank Deputy Hewland, because as much as we have differences on issues, we do respect each other, and we have tried to work together on this, and we continue to work together when it comes to the migration control. But it has been difficult, and like I say, we haven't agreed on anything. But I think members do need to carefully consider whether this fits the bill. This really is providing the island with a policy that will really get to grips with an issue that's been probably the one issue that's been at the height of public concern for a decade or more, and one that will need to be addressed because we do have limited resources in the island, and we are going to have to consider how we use those resources and whether we're comfortable carrying on in the vein that we have over the last 10 years by increasing population by 1,000 a year. Most people, I believe, in the island find that it's unacceptable. And if that is to be the case, and we want to listen to the public, something we're not very good at times, then I think we are going to have to really consider how we get to grips with reducing the number of people that come to live in the island. I think I'll stop there because I think the report says a lot of what I really wanted to say, and I'll let members decide whether they want to vote for this policy today. But again, thank everybody for listening. Thank you.
Thank you very much indeed. Is the adjournment proposed?
Yes, sir.
Very well. The Assembly stands adjourned until 9:30 tomorrow morning.